Well, I'm mentioning application for inclusion.
Served after service. Have you served?
In connection, second application.
Have you served?
Yes.
My lord, 2 restoration application, 1 contested application. Served, notice, track report, 5.
May I permitted to speak for inclusion?
After service.
Inclusion, my lord. Inclusion.
Served.
I inform over telephone. I inform the other side over telephone.
Serve and come back.
May I have your lordship kindly to mention for inclusion service has been done, my lord.
Lordship, may I permitted I mention the matter 104, my lord. Is the section 5 application, my lord, fixed at 2 p.m., my lord. I shall inform the other side, my lord. Fixed at 2 p.m., my
If
lord.
time permits,
2 p.m., my lord.
if
Kindly.
time permits, it will be taken up. 104.
104, my lord.
Let's see. Hey, এটা একটু এগিয়ে দেবেন তো যদি আজকে না হয় ওনার একটা section 5 করবে।
Grateful, my lord.
May I have your lordship?
If not today, tomorrow, of course. Yes.
May I have your kindly to mention item 8,
Grateful.
my lord. This matter is covered by the judgment of Parashat Eye Hospital, my lord, regarding the non-payment of the entire consideration money in a preemption case. So it is well covered, my lord. Although ground of rejection was something else, not part of the plot of the land, but this point is covered in this matter. So I was saying it appears to be mentioned. Shuddha Satya Banerjee is for the petitioner. I am for the opposite party. Pending for a very long time. If possible.
Item number 80.
80.
এটা কালকে একটু রেখে দিন না সামনে।
I shall inform Mr. Banerjee and on record. Much okay.
Yes.
My lord, I am appearing on behalf of the respondent.
You are appearing on behalf of the respondent. Appeal is accepted and the judgment impugned is set aside.
I am
appear on behalf of the appellate.
I am appearing on behalf of the respondent. My lord.
Just for a minute. Mr. Poddar. Yes, my lord. Your appeal is not accepted, my lord. Sorry.
My lord, kindly, NCR is sent down, my lord. Special cost, passenger cost.
Very well. Call the next one.
Grateful, my lord.
Sorry, Mr. Ghoshal. I am not with you. I tried, but it was really difficult.
Whatever my knowledge about, because I was upon these judgments, I didn't like to inform judgments. There are other judgments also on this point. Extreme cases are there. However, whatever my knowledge.
You didn't disclose your mind before I pronounced the judgment. You could have.
No, that is because I thought.
I would have. No. Actually, in 2013, Honorable Apex Court, our then Chief Justice, this is Deepak Misra, laid down principle to be looked into while dealing with an application under Section 5. So I was following that.
We are bound by any pronouncement, but contradictory judgments are there.
You could have expressed your mind. I wouldn't have pronounced judgment.
In fact, I could not anticipate. That's why. Because the matter has not been considered in that way. Anyhow, whatever my order is binding on. Whether by imposing cost, it can be funded.
No, I don't mind. Subject to the consent of your friend, I can reopen. If Mr. Dotto comes and say, all right, let Mr. Ghoshal have his say.
I'm told that Mr. Devdatta Basu is appearing. He's in
Yes, I
Lake,
know that.
he's in Lake, Lordship. On his request, Lordship, I'm praying for short passover.
Short passover.
Lordship.
Very well. I am passing over the matter. Let Mr. Dotto come.
Whether subject to losses kind sanction. Whether it can be for further hearing.
Let him come. Let him come.
Further, no question of consent, difficult to give consent for a lawyer.
No, I don't seek his consent in disposal of the application.
For further hearing, we reject whatever law can decide. If it escapes from further hearing.
What I-
Decided upon.
What I think, we should all be fair. I should inform him, look, this is the situation. Now at this juncture, Mr. Ghoshal wants to come back with certain judgment to,
I said to take a chance.
yes. I have no issue. If your friend agrees, I will consider everything.
I generally, at this age, I cannot tax with the honorable courts with the plenty of judgments, unless multiplying the judgment. That's why I avoided multiplying the judgments. Anyhow, why not subject to loss of sanction, let my friend come,
Yes.
and subject to the further hearing.
Then instruct your advocate on record to inform Mr. Dotto
Yes, my lord.
and come
I
to
am-
it.
Order Devdatta is on the lake, my lord, kindly short passport.
Ask Mr. Dotto
My,
to inform Mr. Ghoshal and come to me, to my court with Mr. Ghoshal. Both of them should come together.
yes, I will inform. My, deeply okay.
But Devdatta is, I can also, if I see him, I can also.
Yes. Both of you may come. Let's see. Five,
My lord, I appear on behalf of the petitioner.
are you ready?
My lord, on the last occasion, my lord had directed me to serve the order of the on this honorable court upon the opposite party. My lord, I have served, but the items have not been delivered yet.
Delivered as yet.
Yes, my lord. That's why the affidavit of service could not have been prepared. I have served upon them in the process of delivery.
When should we fix the matter?
My lord, kindly kindly gives me 10 days because my lord, as it would appear from the advocate on record, Mr. Aniruddha Chatterjee is the advocate on record, my lord. His father unfortunately passed away. So kindly keeps it on 24th or 27th, any day after that.
একটু এ করুন তো। You are Mr. Khan.
Yes, my lord.
On the prayer of Mr. Khan, learned counsel for the petitioner, the matter is adjourned to appear on 26th of July. Start. On the return, on the adjourned date, affidavit of service is to be filed by the petition.
Grateful, my lord. Grateful.
On the occasion, my lord, state appeared. Now, today, the
There
learned
was
lawyer,
direction to serve upon GP, no?
yes, I have served it. I
Okay.
have served it on last occasion, I was not there, but the state was represented by a lawyer. Today, over the phone, the learned lawyer requested the advocate on record to seek a passover on his behalf.
To seek a passover. Okay,
Yes.
I am passing over the matter. Till the time I am here. Yes, then corrected up. Take it in. After the.
I'm going to apply for the affidavit. Lord, the appeal has been admitted and has first last appearing before the division bench of Honorable Justice Tawagura Chakurya. It was released from my lord's division bench and
Record to the.
before my lord for only a prayer for direction to file the papers. Now, there is one application pending which is yet to discover CAN 3.
You were for the appellant.
I would that.
You were supposed to prepare the paper books.
My lord, without my lord's direction, my lord. And there is one application pending that is to be disposed of. CAN 3. That is the application for injunction. My lord. This pending
Application
since
for
2021.
injunction. There is an order of status quo.
The status quo only with regard to kindly see the order of status quo. It does not say with regard to nature and character. It only says in regards to possession. It is admittedly that my possession is not with me, it is with them. Now they have constructed a building. They have changed the nature and character. That is my prayer in the application.
Have you served upon them?
Because several times I have served, before mentioning also, but I have served a notice for this. Just been delivered. Thank you.
Very well. I'm fixing a date. You file affidavit of service in the
I shall,
meantime
Lord.
and indicate the date of hearing again afresh
I
to
shall.
the opposite party.
I shall, Lord.
Yes. The office report reveals that the appeal is otherwise ready, but no direction was given to the appellant to prepare paper books. Stop. Mr.
Abhilal Chakraborty.
Abhilal Chakraborty, learned counsel for the appellant, submits that the appellant shall comply with the appellant is awaiting the direction for preparation of paper book. Stop. Appellant is directed to prepare requisite number of paper books within 2 weeks.
My lord.
2 weeks.
My lord.
Within 4 weeks. And serve copy upon the respondents. Stop. It is further submitted by Mr. Chakraborty that an application for injunction is awaiting disposal. The appellant is directed to let the matter be posted for hearing on 19th of July. Appellant is directed to notify the respondent about the date of hearing of application. Liberty is given to the respondent as well to file affidavit in opposition, if any, by the date fixed. Let them come back. Perhaps they will again seek for.
I'm sure.
Yes. No, it's okay. Now Mr. Ghoshal wants to make further submission.
Lordship has the obligation to produce documents, your lordship.
Next Wednesday.
Why not today?
Yeah, take out those things.
Now, no, the matter is running under the head for judgment.
On Monday. Well, I have meeting space to take out these copies.
Most difficult part would be to explain the inaction of all 7 persons or all 6 persons. That is the stumbling block I am telling you. There are 9. According to you, 3 were indisposed. Fine. What about rest 6?
But there are 11.
Well, I reserve my submission right now. Well, my lord, long experience knows that we generally 1 or 2 members come forward of the entire family. That's the usual way. I have tried to impress upon a lot of that. Whether that is the fatal or not. Because all of
A right has been accrued to your other side. You want to snatch it. So there must be some strong reasons.
My task is heavy. So let me try to discharge it in my humble way. Monday, my lord, hard in part.
As your lordship desires. I leave it to your lordship. I have got nothing. My senior friend is seeking for an adjournment on the ground to oppose me in a better way.
No, oppose
In a better way.
I shall try to clarify in my humble way.
Equipped with more decisions. And to assist your lordship also.
Very well, very well.
But it will have time to learn during all
When-
these years.
When Mr. Datto doesn't have any objection, I will lend my ears to you. No issue. Nin, likhun to.
I will also get opportunity to learn from something my senior.
Madam Ashu. Today is fixed for.
Don't take me, I missed in one of my matters. 10 years delay was condoned by the bench of justice in court rule number 19. And another, that's almost to 7 years contribution.
It varies from fact to fact, you know.
So I shall try.
There is no straight jacket as
I shall
such.
try in my humble way with all my
Fine.
intentions.
Fine. Today is fixed for pronouncing the order disposing of the application under section 5 of the Limitation Act. Stop. Mr. Ghoshal Learned, counsel for the petitions, submits that he wants to come back with some more judgments of Honorable Supreme Court to buttress his argument. Stop. Mr. Dotto, learned counsel for the opposite party. Mr. Basu, sorry.
But his father was a lawyer of this court.
No, he is full of surnames. What can you do? Dotto, Basu.
His father has great affection for me.
Okay. Which is why he is respectful. Yes. Mr. Basu. Has no reservation to such submission. Hence, the matter is
keeping it.
matter be listed on 17th of July Under the heading further hearing. Under the heading further hearing, yes.
Well, just after mentioning, I think I covered the earliest. I think you mentioning it.
Hmm. Look,
Look at the petitioner, my lord. I pray for not today, my lord, because Mr. Dilip Kumar Sadhu is an advocate on record. He could not come to this court.
this is the fourth adjournment. Tell me the number. Second, fourth, third. How many adjournments? You don't know. Let me see.
Not this. Make it not this.
I adjourned the matter on 5th of June. Then on 6th, 14th. Now 30th. This is the 5th.
Last chance, my lord. Make it last.
Not today means tomorrow it will be appearing.
My lord. Kindly make it not this week, my lord.
Have you deposited money? You don't know. It will be dismissed simply. The only option to be followed. If you don't comply with the direction, it will be dismissed. Come back tomorrow.
My lord.
Not today, sir.
I'm for the appellant, my lord. As per your lordship direction, my lord, copy has been served upon the all parties.
Lordship, I appear on
Now-
behalf of the respondent number
Filing
120
affidavit in opposition.
as directed by your lordship.
So lordship,
Affidavit
give
in
some time
opposition.
to give reply of the, and also to file the affidavit of service as well.
So application under section 5 is pending.
Pending, and she has filed opposition of it. So I have to file reply, my lord.
I beg to appear in this matter for the respondent number 60.
But you have
Very well.
But here, my lord, one thing, my lord, my name is my lord, Mazharul Islam. But it has been mentioned here, my lord, Mazharul Haq. So far my wakalatnama is concerned is my lord Islam.
You were the respond number
16, Mazharul
16.
16.
17, she's
So it is
No,
total of-
7.
so it is 17.
Mojaharul Haq.
Lordship.
It should be Islam.
Lordship.
get a fresh
Since-
Wakalatnama, Majul Haq, Majul Ali. Majul
I
Islam.
have received the
You can take
wakalatnama.
exactly.
The thing is, since he has appeared, liberty may be given to you. You may correct this. You may correct the cause title.
If it is not in the trial court, if it is in the trial court, by that name, my lord.
It is in the trial court.
Trial court is
Decree was passed in the name of.
Wrong then.
in the trial court. Well, I have to check my records, my lord.
Yes,
I have to
if,
check
if,
my record.
if it's
Because
simply a
when-
clerical error,
Appellant advocate on record is constant is in my lord. Panchayat election.
wait,
And lordship, give me time to reply of it, and by that time I'll let you. I'll give reply of the opposition.
suggest a date.
Oh,
Then we can't help it.
collector,
Then it is to be sent down again for correction, etc.
yes, correct.
My lord,
Unnecessarily time will be lost.
so for ends of justice, my lord,
Let him take a Vakalatnama, Nazrul Haq, Nazrul Islam. You can do it. There is no doubt. শুধু মামলা পাঠাবে আবার আসবে
just I'm just being officer of the court applies your lordship. She take note of the point.
Now, what is to be done? The only way is to send it back. It will be time consuming affair.
So your lordship given.
The other way is you can file an application that you are known by both the names, Haq and Islam, alias Islam. I may direct the, because I cannot correct the decree.
Obviously.
we have to follow the decree.
Lordship.
So only we can add as a concession Islam
No,
along with Haq.
That suffices the purpose. That's suffices. Well, on the next issue that I might come with an application.
Suggest a date, Mr. Chakraborty,
My lord.
when it should be
Or
posted.
your lordship
Malak,
corrected
For
Wakalat.
reply, my lord, let it be at least, my lord, 2 weeks. It is from Dokhin Dinajpur, no, my lord, 3 weeks. It is from Dokhin Dinajpur. So at least 3 weeks time. तुझी कल के टाइप करना नहीं चाहिए.
Hey, Nintu,
Or
would you like to file any opposition?
My lord,
Have you
one-
filed Vokalatnama?
my lord, I cannot depose it. I have brought the Wakalatnama in your lordship can just for your lordship perusal. My lord,
Executed as Islam.
Islam. Because all the
No,
documentary evidence I have checked it whether Islam or Haq, but it has been Islam.
Ask him to use both. Alias Haq.
Or alias, I should make it a Haq and
Yes,
deposit
yes,
before
that is what I am saying.
or deposit before the registry. Your lordship,
Fine, fine.
that will suffice the purpose.
Alias Islam.
Nah, Islam আছে, alias Haq.
हाँ.
Miss Papiya Chattopadhyay submits the affidavit in opposition to the application under section 5 of the Limitation Act
The notice of people.
on behalf of the respondent number 1. Stop. Mr. Basu, representing the respondent number 20.
It's not Mr. Bashu.
Oh, I'm sorry,
Mr. Korim,
Karim. Mr. Karim.
along with my junior, Mr. Ranjana Talab.
কত নম্বরে
Okay.
17 হচ্ছে।
17. He's appearing for 17.
Mr. Karim is representing the respondent number 17. Liberty is given to Mr. Karim to submit Vokalatnama in the department
কোথায়? এখানে তো 16 হচ্ছে।
in course of the
কি করছে? কোথায়?
within 2 days.
মানে one thing, মানে এখানে তো 16 হচ্ছে আমাদের জন্য।
আচ্ছা দেখুন.
Plainton, মানে 16, that should be 16.
16.
16. In plaint, I was 17, but in
In the memo of papili was 16.
lordship,
Fine. Respondent number 16 করে দিন.
Mojarul Haq,
Yes,
1616.
16. ওটা 17 না 16 is given liberty to
আমাকে
submit
যেটা সেটা 16
Vokalatnama in the department within 2 days.
Yes, I do.
Within
In course
2
of the I shall find.
কি করবে? তুমি একটা কারেকশন করবে তো?
But one thing,
You have to correct it.
signature that has to be obtained
Yes,
from-
that is.
in lieu of Haq.
You just ask your client to write alias.
Uttar Dinajpur.
It is from Uttar Pradesh.
So in course of a week, better.
Oh, we can,
In course of a week.
that will suffice the purpose.
Stop.
Dokhin Dinajpur.
As suggested by Mr. Chakraborty, matter is adjourned to appear
বুনিয়াদপুর.
under the heading hearing on 31st of July. In the meantime, affidavit in reply, if any, is to be filed by the petitioner appellant. You are at liberty if you want to oppose
Is
it.
that to be?
ওই জন্য তার তোমার copy দেওয়া.
But in that event, just give the copy of your opposition to Mr.
Yes,
Chakraborty
given.
beforehand.
Given to-
No, so far my party is concerned.
Ayo.
A copy of the affidavit in opposition on behalf of the plaintiff respondent number 1 was served
That I have
on the
received. That-
No, he is not disputing. He
No,
wants to
that's-
come back with reply.
lordship.
I'm get to know.
So kind of law.
I'm appearing on the respondent number 1.
What about the appellant? Who is representing the appellant?
Mr. Ghosh was appearing. Mr. Gopal Ghosh.
The last occasion, yes. Where is Mr. Ghosh? Prashant Banerjee, Indrani Nandi, Gopal Ghosh. None is present. Yes.
Only one question.
10 minutes. দেখুন পরে একটু দিন।
Team Lord, I am for the appellant. Other side is not here. But one thing, Lord, I am submitting on the last occasion. So if I call for this for certificate, it is 67 suit. And my lord, I have no plain copy of the plain, copy of the written statement, as well as no documents.
How could you accept the brief without any paper?
No, 67 suit.
So what?
But if I will.
Suit is of
deposit the-
67. Appeal is of 2022.
I will deposit the special procedure.
What is the suit?
Suit for more eviction. Their case is I am a tenant, my case is I am a Thika tenant.
Why the LCR will be required? It's a question of law only. If you can prove you are Thika tenant,
Requirement, there are some documents that I have to prove that I am a Thika tenant. Documents is there.
exhibited,
Yes.
then
And
then
on
then
the other hand, Lord, other documents also I require. But I have to see Lord the record. Without.
you have to
record-
see.
Yeah, without record. Lord, you
Ask your client to pay you adequately, go and have a look in the trial court. In
But I
second
will-
appeal,
But I
LCR
will deposit, Lord, within a week, Lord, it is seal the court.
67, that means 33 and 23 means 56 years.
But I will.
And you want to add 10 years more.
No. Lordship kindly call for the records, but within 2 weeks, not it will come. I will deposit.
Again, that 1967.
That's your lordship. Knows, but blood I require blood. Blood I, unless I,
You do one thing,
Every-
you do one thing, you obtain certified copy from the record of
entire
learned trial.
documents, not 67 documents, long blood. Long.
It will be an asset to your client.
Blood, it's very deep. And it will take time, Lord.
No.
Certified copy, it will
No,
take
no.
time.
That direction I will give within 10 days, 15 days.
Your
That they
lordship,
will
your lordship give, blood, I will entire documents, I
Who
will.
is the appellant?
The
You are
document-
you are the
Blood,
appellant.
I am for the appellant.
How could you claim Thika tenancy?
But ticket is still for they are serving notice still for hearing. They are not appearing, but we are still.
What is that still?
Everything.
No, that is not your pleading as well.
Yes, my meeting is there. I am a ticket in.
Then you must have adduced evidence.
Yeah, I have evidence. That is why not but it will take not, I think not seal the court 10 days, it will take 10 days time. If I deposit.
Why it was not called for by the division bench?
But called for, but it required the appeal
If
court.
required.
Yes.
Let me see where lies that requirement.
Yes, your
If
lordship,
required,
one
if
thing
required.
Your lordship can see, your lordship have a judgment of this honorable court, Justice Jane Ho. Your lordship have.
No, why it is res judicata, your substantial question number 1?
Not your lordship. But
Why it is res judicata?
it is duty, Gata.
Whether on the facts and in the circumstances of the case, whether the appellants were tenants under the respondent had become res judicata by virtue of finding of a competent
Your
court of
lordship.
law.
Which document your lordship?
No, I am reading out the question number 1, substantial question number 1.
But that I have to blood.
So if it is a res judicata, then
Your
there is
Lordship
no room.
kindly- Your Lordship kindly see below the Justice Jehan would judgment. Your Lordship have.
On this matter.
Yes, have. I have on the last occasion I have.
Yes,
Your Lordship can see. Have your Lordship.
property is Debottar.
Yes, Lordship can see page 10 of that judgment. Page 10. Your Lordship kindly see in the middle portion. Their case is after Gopal Jha, his wife Rajlakshmi was in possession of the disputed land. And after Rajlakshmi's death, Kishori Chakraborty being the executor and legatee of her will, possessed it. And after Kishori's death, his wife Chamunda Devi has been possession. But whether the Kishori obtained the probate, that was
That you cannot agitate. How could you?
Blood, on the basis of that,
Who inducted you?
nobody.
Nobody
Chamunda
means
Devi, no.
you are not trespasser.
No, I am not yet today.
You are a Bharatiya.
That these court.
Mr. Bhattacharya, according to Mr. Bhattacharya, please. According to you, someone must have inducted you as Bharatiya.
That is Jomindar, original Jomindar.
What is his name?
Not that his name is Rai Chowdhury. Rai Chowdhury.
And Rajlakshmi is claiming under him.
No, Rajlakshmi, but Rai Chowdhury filed a suit against Chamunda.
No.
Chamunda Devi,
Who inducted
relative in
you?
this case.
Who inducted you in the
Blood
suit
Rai
property?
Chowdhury. Initially, Rai Chowdhury.
The original owner. The original owner. For how many years you have been possessing the property?
Since long, before 1950. My predecessor in kindly call for it will not take more time.
First, let me go through the documents. Then, that is the direction of the Honorable Division Bench. How could I flout the direction?
Then it will, your Lordship understand. Your Lordship.
Yes, I need to understand.
And there are several. I have no copy of the plan because predecessor interest is 1967 so. But I have no document.
Have you a prepared paper book?
Paper book, trial court and appeal court. Judgment. Second appeal. Your Lordship knows.
Where is your client?
Client.
Yes.
Client, I have. No, without paper, Lordship can see 99%.
No, I want to.
99%.
I want to.
Your Lordship, after calling for the record, your Lordship, gentlemen.
No,
99%.
I want to see your client who considers you as omnipotent without any document, without evidence. How could you assess the court?
Only the judgment. Judgment is not sufficient. Your Lordship can see. Your Lordship can see the memo of appeal. Your Lordship have seen what we have take a ground. This honorable court direct the trial court and the appeal court to consider the case of relationship. But they have not learned, they have stated that as there is a rent receipt, so he is a tenant. I am not required for deciding the relationship.
Now, how your application?
I have a ticket and I have produced the document.
How your petition under section 17 was disposed of?
I have a document. Judgment is there. Judgment is your Lordship. I have on the last of it. I placed. There, not everything is there. Last portion is the trial court decide the relationship between the parties.
As landlord and tenant.
Yes.
Did you challenge it in the appeal?
No, not required because I placed that. I before the trial court, I faced that I am not a tenant. I have a ticket.
It was not accepted.
No, but the document is there. The khajna treated as a rent receipt.
No,
Then,
no,
Your Lordship,
your
kindly-
landlord was a
Lordship,
ticket.
kindly-
First, you have to show me your landlord was a ticket tenant and you were a bharatiya under him. That's it. Show me the document.
But I have no document. That is why I am submitting a lawsuit.
Then your client is not sincere.
But see, not
I
Your
definitely-
Lordship, kindly, my lord, call-
Your client
or
is
your
not
Lordship,
sincere
kindly-
and there is no room
Lordship,
for.
kindly direct, I will
No.
apply for certified copy.
No, no,
I
no.
will apply for certified.
Nothing doing.
I will apply for.
Today is fixed for hearing of appeal.
Not appeal, yes.
Yes.
But
You better start arguing
but
your
I-
case.
No, I am not ready. Today come, just come.
No, sir. On 5th of June, it was adjourned.
Yes, but now that suddenly
No,
come.
then suggest a date. Suggest a
But
date.
Lordship, kindly call.
No.
No, we don't-
Nothing doing. Suggest a
But
date.
I-
I
how-
cannot flout
but
Mr.
how-
Bhattacharya.
but
The direction of
How I prove before Lordship
it will amount
without
to
a documents?
it will amount to judicial indiscipline. There is an observation from the honorable division bench.
Yes.
Let me understand. If necessary, I will definitely go back. You suggested it. Take down. Mr. Bhattacharya, learned counsel for the appellants,
Then
is seeking an.
two times it will be, your Lordship will have to.
I shall be glad to hear you twice. Don't worry. Is seeking an accommodation. Yes, let the matter be adjourned to appear on suggested date when you will be comfortable.
Make it not next week. Tuesday, Wednesday.
The matter is adjourned to appear on 19th of July under the heading for hearing as suggested by Mr. Bhattacharya.
Oh, then my Lordship going to make it 20.
20. আরে তো কটা সেকেন্ড অ্যাপিল আছে 20 তারিখে There is no point. After I can't take up your matter on 20th.
21st. আছে
এরকমই না আমি 20-21 অনেকগুলো চেয়েছে
ঠিক আছে
then you come
But
back
if
on
you-
24th.
Yes, your Lordship. Not if any, yes, 24th, Lordship. 24th, if there is any problem, Lord, your Lordship.
It will be
Accommodate.
shifted to 25th and on 26th it will be dismissed for default
No, your
with
Lordship
cost
will-
of rupees.
No, your Lordship will
No,
not
no.
dismiss. Your
I am telling
Lordship
you,
will not dismiss.
24th I will adjourn,
Yes.
25th I will adjourn, 26th I will dismiss with cost of rupees 5 lakh CP. So convey this message to
Lord,
your client.
Lord,
Call the next one. ডাকুন তো মিস্টার ঘোষ এসছেন তো yes sir come your appeal
70.
LC একটা দিন Yes, she's now present. With the consent of Mr. Ghosh only.
I'm waiting.
The suit filed by me, by my client against the state of West Bengal and land department. Inter alia on the ground, the subject matter of the suit was that the state has constructed a technical institute adjacent to my premises, and they want to get access from my land. So the dispute pertains to that only. My lord, may I take your lordship straight to the order passed by his lordship Justice Banerjee, Justice Sanjeev Banerjee, that is appearing at page 12 of my application.
Page 12 of your
my application. There is a CAN application. It's a main application. Your lordship is.
Where's the
There is
number?
a CAN application filed in 2023.
আরে তো দেখুন তো আর কোনো অ্যাপ্লিকেশন ওখানে রয়েছে?
It is appearing in the list.
কিছু নেই.
Extra.
Lordship, I have an extra copy.
Do you have copy?
I've got an extra copy, Lordship.
Your lordship, kindly come to page 12 of the application. That is order dated December 15, 2014. My lord, we'll see in the first paragraph. Though the state is represented, the appropriate officials of the state are not represented. It is also necessary that a copy of this petition, along with the copies of the order passed herein, and the map of the proposed access road, as suggested by the petitioner, be forwarded to Premchand Jute and Industries Private Limited. For Premchand Jute and Industries Private Limited to be represented when the matter appears next. Premchand is not a party to the suit, but in the instant proceeding he was directed. Prima facie, it appears that the suggestion made by the petitioner, that means me, should be accepted to all, since the alternative route travels through most of the petitioner's property, except a stretch of about 100 feet to bypass a temple and another stretch of about 300 feet to bypass a mosque. Let the petition appear on such and such date. Since the state appears to take little interest in the matter, there will be an order of injunction restraining the state from using or allowing the use of any part of the petitioner premises for access to the ITI premises. Now, your lordship, prior to this order, there was another order passed by this honorable court that is appearing at page number 9 of the application. That is dated September 9, 2014. The matter requires a solution. This order was passed in presence of the state. The matter requires a solution by negotiation that may not be possible in the absence of Premchand Jute Mill, which owns a land which also contiguous to the property marked as Schedule C to the plate. The grievance of the petitioner is that a technical institute is proposed to be set up at the property marked as Schedule C to the plaint, and land exclusively belonging to the petitioner is sought to be used as the access to the property. Now, as your lordship has seen, the initially this honorable court attempted to settle the dispute between the state and the parties. At the relevant point of time, the matter was not settled. Now in January 2023, page 14 of my application, the chairman of Uluberia municipality representing the state has settled the dispute. Parties have arrived into a settlement.
Fine.
Now, my lord, the difficulty is this settlement is executed by the municipality. In the suit, land department was a party and the state of West Bengal also. Now this settlement can only be given effect when it is filed in the suit, because there is a suit is pending and injunction order is passed by this honorable court. That is still subsisting from 2014. No steps taken by the state. Obviously, after settlement, now what is required to be done? This settlement.
What prompted you to approach this court?
Yes, yes, my lord. I am coming.
First, you tell me.
Yes, my lord. The lower court record has been called for by this honorable court. The lower court's record is.
You were aggrieved by an order of injunction.
No, I'm not aggrieved by this order of injunction.
Then
the injunction is suffering by the state. State is suffering in order of injunction. Injunction is in my protection.
Then who preferred this revisional application?
I have preferred it.
Why?
Because the suit court, I did not get order of injunction. I went to before the district judge. There also I did not get. Then I filed the civil.
That is what I am telling you.
Yes. Here I got the protection. And the order of injunction is still continuing from 2014 onwards. Now in the meantime, parties have arrived into a settlement. That is at page 14. Now, my lord, what I am seeking by this application, that let the lower court record be sent back to the lower court, to the trial court, so that terms of settlement can be filed before the court and a compromise decree can be passed pursuant to the agreement. Because until and unless compromise decree is passed, this settlement cannot be given effect.
I cannot direct the trial court to arrive at a compromise.
No.
It is the judicial discretion to be exercised by the court.
This is my submission.
All I can do, I
Yes.
can dispose of your application.
Yes.
And I can send back the
Lower
court record.
Yes. That is
before
my
the learned
prayer.
trial court.
That is my prayer.
That is the prayer, Lord.
That is
When
the
it comes
prayer.
to the
Yes.
prayer of
Just
the
now
CAN
what-
application, that is the only prayer she's
Yes.
she's seeking.
I
for.
have sought, let
Very
the lower court's record be
Right.
sent back. And my lord, till that,
এটা কি LCR এসছে আমাদের কাছে?
and the order of injunction be continued.
Who told you that LCR has been called for here?
My lord, I
Are you
personally
sure?
check. My lord, I personally checked the record.
LCR is with the department.
There was a notice issued by the learned registrar of this court at in 2014, where the record was called for. Lower court trial court doesn't have any record.
দেখুন তো।
There was an issue. I have checked the record of the trial court where I have seen it.
In the department?
Yes.
In this department?
In this department.
Record is here.
Yes.
Sure.
Yes. I have checked the lower court's record there.
In the high court?
Not high court. In the trial court. In the trial court, there is a.
My officer is saying that lower court record has not come. You were saying I have seen it. Where did you see?
I have seen notice in
The
the trial
notice is
court
something
records.
different.
Not here.
Not here.
Not here.
I mean, Ashwin, it is submitted by Mr. Hussain, learned counsel for the petitioner, that the parties at the behest with the intervention of Chairman Uluberia municipality, not the parties, municipality was not a party.
Yes. This is the difficulty. Lord. So the order of
It is
injunction
submitted
should be
that with the
continued.
intervention of Chairman Uluberia municipality, a settlement has been arrived at Stop. Mr. Hussain is seeking direction to send back the lower court record with liberty to the petitioner to approach the learned trial court to record a compromise and dispose of the suit. Stop. Miss
Amrita Paja Maulik.
Amrita
Paja Maulik.
Paja Mollik.
Lordship Maulik. MOULICK. Maulik.
Maulik. Oh, I see. Paja Maulik. Huh? Learned counsel representing the state submits that state doesn't want to stand in the way of settlement. Stop. Therefore, I am inclined to allow the prayer. The law department is directed to send down the lower court if the record has already been received by the department immediately to facilitate compromise between the state and the petitioner. Stop. The interim order.
Yes. At page 12, my lord. December 15, 2014.
Passed on 15 December 2014 shall continue till the suit is disposed of by way of compromise. Stop. Thus, the civil revisional application is disposed of on consent.
My lord, may I seek, my lord, one line direction, my lord, upon the trial court?
Nothing.
So that within a
Sorry, sorry.
My lord, my lord.
Just go,
Yes.
sit there.
My lord.
Grateful, Lordship.
Your
Don't seek
lordship-
adjournment, matter will be taken up. On consent.
Yes.
Yes, Mr. Ghosh.
Grateful.
21. I think you should take only one. Because application opposite particular over and die with 5 minutes time. What is that? How do you allow push that? I have a question. We have to sub copy of that. That is. Otherwise, the letter cannot be.
Mr. Ghosh is getting ready.
Is getting. There's no objection. I think there's no objection. But he is getting ready.
Because once his matter is taken up by Lord, then
You were.
I am item 20.
And we are at item number. I hate motorbiking.
Yes.
Come.
But it will be because by code 30 code number is very faster. That is the reason.
Just wait. Let me do this matter.
I think it will take time.
Door photo আছে জানি না
দেখি একটু দিন এলসি একটা দেবেন
না হবে
ইয়েস
লোয়ার কোর্ট রেকর্ড আসেনি তো আজকে জানা এখন But in connection with this appeal, Lord, we have filed an application and order for rule 20, order for rule 27 of the Code of Civil Procedure. Lord, if you Lord, go through the paper book, the defense case has recorded by the learned court below.
This is a suit for
Declaration and injunction.
injunction.
Yes. Lord, what happened, Lord? If your Lordship Lord goes through paper book, Lord, where the defense case has been,
paper book ta din. Yes.
defense case has been recorded by the learned trial court. Lord, it will appear that the defendants have practically practiced fraud not only upon the court but upon the plaintiff also. Lord, they have stated that the vendor of the plaintiffs are some persons who are sons of one
Rabindranath Gupta. But not it appears that they are not at all sons of Rabindranath Gupta. They are sons of Monindranath Gupta. They have no concern with the property. But they have stated such. And so far, the
No, you are the appellant.
appellant is the plaintiff. But the suit has been
No,
dismissed
you are,
on two
you are
grounds.
appellant,
Appellant, plaintiff,
plaintiff,
appellant,
appellant.
plaintiff, appellant.
Fine.
But the suit has been dismissed on the ground of defect of party and said not that I have purchased a property from the one heir of this Rabindranath Gupta. But the learned court would have that it is section
এই,
4,
এটা কি হলো পেপার বুক কোথায়
section 14 of the
ওখানে রয়েছে
section 14 of the Land Reforms Act has been referred to.
হুম
Because I have purchased, it is not partitioned. That is the ground. They have taken the ground that it is not partitioned. Therefore, my suit is not maintainable. I have acquired no title in absence of any partition. And Lord, partition can be done only by a registered deed of partition or by degree of a court. But these two on these two for ground, Lord,
if
I
it
have
is
lost.
post 69
Yes,
there is a cut-off date perhaps
65,
69 or 5
65.
5
Lord, chapter 2 came into operation.
okay
That is not that so far that my title is concerned. That has got no relation at all.
no what was your prayer before the trial court that is what I'm
Declaration, Lord, I am the owner in respect of the property on the basis of purchase from the
so you have acquired property undivided share by purchase you have acquired
Lord, it is the in the deed it has been mentioned that one such and such one Rabindranath Gupta was the original owner. Lord, his heirs amicably settled there amongst them the properties and my vendor got that property and my vendor has sold it to me absolutely 9 decimals of land.
when
That is not 1980.
When did you purchase
80.
1980
Yes.
then
I purchased not so far that they have no dispute at all. His heirs have not come at all. And not though I was directed to add them parties, added them parties. Now it appears those persons who have been added as parties, they have no concern with the property. They are not the heirs of Rabindranath Gupta at all.
who are the respondents
Respondent, Lord, is a member of a club and a adjacent owner of the plot. Everything has been set up for the purpose of grabbing my property, to grab my property. And during pendency, Lord, I have been
yes
dispossessed from a part.
you have been dispossessed
Dispossessed from a part, Lord, that's why an application for amendment was filed before the learned appellate court. That was pending. During pendency of the that application, this
club has constructed a building or half done construction
Lord,
is
what your boundary wall has been given, thereby narrowing my egress and ingress. If some person die, Lord, he will have to carry by persons to come out from the house. This is the position. And Lord, they have admitted that there is no altar or there is
So-
no construction of the DW1.
now the suit is for declaration recovery of possession
and injunction.
there is no prayer for recovery of
The
possession
recovery person was not there, Lord, we sought for addition.
Even if that was.
then how could you maintain the suit
Lord,
admittedly having been dispossessed without seeking restoration
Lord,
of
dispossessed during pendency. All through our cases, Lord, they have admitted there is no
during during okay very well
yes. Lord, DW1 has admitted that as claimed, there is no altar of
don't make your submission in piecemeal manner
no, Lord, I am not saying.
yes
Your Lordship kindly see the relevance of the application under order for Rule 27. Lord, your Lordship kindly take the paper book paragraph page 4.
Mr. Ghosh, let me hear out the appeal. If I consider that your
That's
document
why,
is
Lord, that's why
required to be,
how these are relevant, I am telling
yes,
Lord. Kindly paper book, Lord, take the paper book page 4. The trial court's judgment. Paper book report.
দেখো, দেখো।
I mean, it's very difficult to proceed, my lord, without the paper.
No, no.
Everything is there in the paper book, and we have to refer.
Do you have a copy? Just kindly lend me for some minutes.
My lord, a lower court record would also be necessary.
Court record is not here. What record is it?
Lend your paper book to me for 10 minutes.
আমার এটা মার্ক করা আছে।
Kindly explain some marking.
Yes.
Lord, kindly come to page 4 of the paper book, Lord, initially, for the purpose of order for rule 27, I am just pointing out. Lord, your lordship, kindly come to the second paragraph. The defendants contended that the suit plot was page 4. The defendants contended the suit plot was absolutely owned and possessed by Rabindranath Gupta. It is not a defense case. And after his demise, the same was inherited by his sons, namely Vishnupada Gupta, Dilip Gupta, Bimal Krishna Gupta, and Dipti Kumar Gupta and Nirmal Kumar Gupta. And they transferred, demarcated 2 shataks of suit plot in favor of Sripati Ruidas in the year 1951. Sripati Ruidas, after becoming owner as possessor of the demarcated 2 shataks of the suit plot, transferred the same on 19th October 1974 in favor of Kalpana Saha, and since then Kalpana Saha is the owner and possessor of the demarcated 2 shataks of suit plot, including the said 2 shataks of suit plot. The rest portion of the suit plot belongs to the legal heirs of Rabindranath Gupta. But 2 things. Here it is said that Rabindranath Gupta's heirs were sons, not only heirs, sons. Vishnupada Gupta, Dilip Gupta, Bimal Krishna Gupta, Dipti Kumar Gupta, and Nirmal Kumar Gupta. They transferred 2 shataks in favor of the defendant number 2.
Sripati Ruidas.
Sripati Ruidas. Sripati Ruidas in turn transferred to defendant number 2. Now, my lord, can you take by our application under
No.
order for
Sripati transferred in favor of Kalpana.
Yes.
Kalpana is
Kalpana
defendant
is
number
the
2.
wife of defendant number 2, 2 and 3. They are dependents.
Yes.
Lord, now, Lord, your lordship, kindly take my application under order for rule 27.
Can
This is can.
আমি একটা সেকেন্ড অ্যাপিল হিয়ারিং করব, পেপার বুক আসছে না, এলসিআর এলো, হোয়াট ইজ দিস? কেন ছিল না এন্ট্রি করা? এটা আনবেন না? ট্রান্সফার অনেকদিন আগে হয়েছে, জুলাইয়ের কত তারিখ থেকে নিচ্ছি আমরা? 6th of June. Don't give me these excuses. Where is the paper book? Don't come with excuses. Paper book কোথায়? যা যা ছাপ মারা স্ট্যাম্প মারার করে রাখবেন, এর পরে যেন এটা যেন আর রেকর্ড না করে। ডু ইউ আন্ডারস্ট্যান্ড? আমি এখানে বসে থাকবো at your mercy, it won't happen. Next time be careful.
Lord, for a can 3, a can 2. Yeah, order for rule 27.
Can
This is not can number. Can number কত?
এই আদিত্য দেখুন তো অর্ডার 41 রুল 27 এর একটা অ্যাপ্লিকেশন আছে একটু দেখুন।
Can কত? Order 27. Order 27.
2 of 2017.
No.
Oh, and 4 of 2023.
Number of 9. Lord, can 4.
of the judgment of learned trial court.
Yes.
Just for my understanding.
Yes.
Basically, your appeal was not accepted by the first appellate court. Now, two things have been highlighted.
Yeah.
First, you were not in possession.
Lord, I am possession.
No. Learned trial court has observed in the judgment there is a club room and a podium for goddess, and Kalna municipality had 4 privy over your
Yes,
land.
yes.
So your possession cannot be exclusive possession.
Lord,
Now, where does the trial court go wrong? You
Lord, I
just
am telling that's
indicate that.
Lord, that's why I am telling. Lord,
Yes.
Your Lordship, paragraph page 4, second paragraph, kindly read.
Paragraph,
Page 4,
page 4,
Lord, second paragraph. Dependent contended.
paragraph 4 of your application.
No, no, no. Paper book, page 4.
Paper book, page 4. Yes.
Lord,
Dependent. Yes.
Page 4, second paragraph.
Yes.
Defendants contended that the suit plot was absolutely owned and possessed of Rabindranath Gupta. Lord, therefore, Rabindranath Gupta was absolute owner. It is the admitted position. Said. And after his demise, the same was inherited by his sons, namely Vishnupada Gupta, Dilip Gupta, Bimal Krishna Gupta, Dipti Kumar Gupta, Nirmal Kumar Gupta, and they transferred, demarcated 2 shataks of suit plot in favor of Sripati Ruidas in 1951. Sripati Ruidas, after becoming owner and possessor of the demarcated 2 shataks of suit plot, transferred the same on 19th October 1974 in favor of Kalpana Saha, and since then Kalpana Saha is the owner and possessor of the demarcated 2 shataks of suit plot, excluding the said 2 shataks of suit plot. The rest portion of the plot belong to legal heirs of Rabindranath Gupta. Lord, I am purchased out of 11 shataks. Kalpana is 2 through Sripati Ruidas, and I am 9 shataks. I have purchased.
Fine.
Net. Well, kindly see now where from Sripati Gupta got it. They said that Bimal.
Mr. Ghosh,
Yes.
we are not on Sripati. The dispute is the suit property is being possessed by the club and by Kalna municipality. Kalna
Kalna
municipality.
municipality, my lord, I am answering
No,
that.
that is the finding of learned
Yes,
trial
yes,
court.
I have seen, I've got.
There is no whisper about a Sripoti or 2 decimal of land, nothing. Over your property, 2 things are there. One is a club with a construction. Second one is municipality with 4 privy.
Yes.
Neither the club
Lord,
nor
the-
the municipality.
That's why I'm not telling that they have relied upon the arrest record of right. So far, Kalna municipality is concerned.
Fine.
Lord, subsequent Kalna municipality was never in possession. There was initially they are aware some lord that Khata Paikhana.
Yes.
That was long
Removed.
back, removed, and it was in the Rabindranath Gupta's land. Subsequently,
There is no whisper in the report of the commissioner.
yes, no,
No whisper.
no.
Fine. Kalna
And
municipality
apart from
goes.
that, Lord, in the LR record of right, after my purchase in 1980, it has been recorded there is no whisper about Kalna municipality nor any.
Goes. What about the club?
Lord, regarding club, Lord, from the evidence of DW, it will appear when at the trial stage there was no club, there was no existence of any room or any altar. Subsequently, it has been done, Lord, forcibly I have stated in the application for amendment and others. Lord, kindly see, your Lordship kindly see the record DW1, Rothindranath Saha, who has deposed. In cross-examination, he has said there is nothing.
Yeah, what about DW2?
Okay, DW on this one.
Rothindranath Saha. Yes. Different number 1.
Yes. Yes, Lord, kindly see Rothindranath Saha. Lord, kindly come to page 2, it is dated date Lord, cross-examination dated 17th January 2011.
Just a minute.
Lord, I'm pressing it.
Just a minute, Mr.
Yes.
Ghosh. Yes.
Lord, got.
Yes. Para.
Lord, it is para.
Cross-examination.
Yes. Cross-examination, Lord, on 17th January 2011.
17th January 2011. Yes. How does it help you? Which statement?
Lord, kindly see. It is in the west of the plot 34, there is a rasta. In the southern side of the shoot plot number 34, the land of Manavendra Rai is situated. In the northern side of the shoot plot 34, the house of Mamata Das is situated. In the eastern side of the shoot plot 34, there is a puku. I purchased my property from Sripati Ruidas. I had purchased my property after perusing the documents in favor of my vendor. I am member of Navaratna Club. The said club is not the registered club. The said club had a room and a platform for puja.
Hmm.
But at present, the room of the club is not in existence.
Hmm.
It to 2011,
Hmm.
not at present 11. The platform is only in existence.
Hmm.
There is no permission of the municipality in respect to the room of club,
Hmm.
which was in existence previously. But my case is that the tile set.
How does this statement help you?
Because Lord, the club was not there. My all through case, club was not there during pendency. That's why, Lord, I filed a suit for declaration and simplicity of injunction where they invaded my right. That's why suit was filed. Lord, subsequently, all these things have been created, and Lord, not a single document is there.
The
But
testimony, Mr. Ghosh, the
Yes.
state testimony you are referring to doesn't help you.
because
There
Lord,
is a platform, even if room is not there.
room was not there. But kindly see, Lord, they have constructed half-done room now during pendency.
Maybe.
How?
Maybe.
And Lord, the construct there was,
Read again.
yes,
Read again the testimony.
yes.
Last line, there is not a fact. The last line is there.
Yes,
I am a member of Navaratna
yes,
Club.
I'm a member of Navaratna Club. This head club is not the registered club.
Hmm.
This head club had a room and a platform for puja.
Puja.
But at present, but your lordship kindly see subsequently they have done of everything. It was not there.
You read.
But
You read.
kindly, at present, the room of club is not in existence. The platform is only in existence. There is no permission of the municipality in respect of the room of the club, which was in existence previously. It
So-
is not a fact that the club was never in existence. Next, there is no document of registration of the Barwari Samiti. There is no document of substantiate that there was Barwari Samiti in the Sud property, in Sud locality. There is no document to substantiate that a club puja was held in the Sud plot with the written permission of the local authorities. I mentioned about the community puja, not about private family puja. I do not have any document to show that Nondibagan Barwari Samiti took possession of the portion of the Sud property by circumscribed the same by fencing the boundary wall. I do not have any document that is ROR in favor of Nondigram Barwari Samiti. Nondibagan Barwari Samiti had not paid any revenue, I must be, to the government authorities in respect of the alleged possession of the Sud plot. Lord, therefore, there was not there. It is subsequently it has been done in order to Lord dispossess me and to affect my right. Lord, I have purchased Lord 9 decimals of land from the rightful owner. Lord, they have made out a case that only from one of the co-sharers have purchased. Lord,
That's fine. Even if you purchase that, you have at best you could have purchased undivided share of one of the legal heirs. Section 40 cannot stand in the way.
yes.
But what about this? You cannot maintain this suit without.
Lord, your lordship, that's why I'm telling you, lordship, can see this Sipoti Ruidas has.
Section 34 is a bar, Mr.
Lord,
Ghosh.
that's why, Lord, we have filed the application for amendment of the plaint, showing that they are not, they were not there, and they have done it, made out a case that they are in possession. That's why, Lord, application for amendment was filed. Your lordship, that has.
It was allowed.
No, it was not at all hard. It was not touched by the learned appellate court. Lord, kindly see the ground for admission of the appeal. That is the ground, only ground now. Sole ground. Other things has not been considered. My lord will, if necessary, will formulate the question of law, substantial question of law in the matter, and thereafter the appeal may proceed. Lord, kindly see that application is still pending. And Lord, that's why I'm telling Lord, your lordship kindly see once before taking that. Lord, the order for Rule 27 application, Lord, kindly see the deed, 2 decimals by which it was acquired. It is their own case. Lord, I am page 10.
Yes, page 10.
Of the Lord, a deed copy.
Title deed.
Right.
Certified copy of
Yes,
title
yes.
deed.
Lord, I am just telling this is the deed by which Kalpana Saha has acquired 2 decimals.
Fine.
Lord, they have in the written statement stated that it has been acquired by Sripati Ruidas, Kalpana's vendor, from the heirs of Rabindranath Gupta. Now I'm trying to see the deed.
Hmm.
Lord, Mouja Sajan Saj, Pesha Srimati Kalpana Saha, Swami Rotindranath Saha Jati Hindu Pesha, Grihokarju, Kalna Lalbagan, Sajan Saj, Vikrita Sipoti Das, Pita Hiru Das, Hindu Pesha Sajan Saj, Sasud Vasudev Bandhubat Sajan Saj, দখলি সত্য বিশিষ্ট সত্যের বাস্তু জায়গা মায় তদুপরিস্থিত যাবতীয় সাজ গৃহাদি দীক্ষাদি সাচন সাজ সহ মিলন কার্জন চাগে কাইলিসি আমি জমিদারি উচ্ছেদের বহু পূর্বে তফসিল জমিদারের নিকট হইতে বন্দোবস্ত লইয়া উক্ত জায়গায় নিজ ব্যয়ে গৃহাদি নির্মাণ করত অদ্যবধি অন্যের সত্য ও সংস্কারাদি বিহীনে সীমানা চিহ্নিত নির্দিষ্ট মতে প্রকাশ্যভাবে 16 আনা রকম খাসে বসবাস আদি ভোগ দখল করত নিজ সত্য পরিচালনাদি মতে গত রিভিশনাল সেটেলমেন্ট রেকর্ডে নিজ নাম 16 আনা রকম সত্য দখল রেকর্ড করাইয়া এবং উক্ত খাজনা আদায় দিয়া দখল প্রাপ্ত হইয়াছি তাতে নিজ সত্ত্বে সত্যবান দখলিকার আছি যে অন্যত্র বসবাসের জন্য খরিদ করিবার জন্য কোথায় বসবাসের গৃহাদি খরিদের জন্য নগদ টাকা সংগ্রহ করতে আমি আমার পূর্বোক্ত মতে খাসমত সম্পত্তি নিম্নের তফসিলভুক্ত সম্পত্তি বিক্রয় করিবার সৌভাগ্য করিলে আপনি therefore it is a total story that Rabindranath Gupta's Sripati acquired from Rabindranath
How
Gupta.
does it help
Lord,
your case?
Lord, I'm telling Lord, your Lordship now kindly see they have stated in the paragraph 10 that Sripati Gupta, Rabindranath Gupta had sons. I have purchased from one of the sons, therefore this is a defect of party. This is one of the ground I have lost in the suit. One of the grounds I have lost.
No. Defect of parties, according to learned trial court, municipality and none else.
Municipality, yes.
And trial court highlighted that club should have been implemented, but your dominance latest you decided not to implement, so you have not.
There is no, it is not a registered club. This is a press of
Fine.
Members of the club are there.
Now the question is,
when the members of the club are there, he can
now
represent
first
the
you
club.
tell me, Mr. Ghosh,
Yes,
how this document
yes,
will help us
yes.
in adjudicating the appeal.
Lord, this will help that.
You have to make out your own case.
Lord, kindly see if the
This
RS record of right has been relied upon for the purpose of showing that this was in possession of municipality.
it goes.
It goes. Because Lord, this person has also, they have their case that this Sripati has also acquired from Rabindranath Gupta. Whether that portion,
No, they are not claiming
previous.
your property.
No, this is my property. They are claiming my property. Entire 9, so there is nothing, no.
Her claim is restricted to 2 decimal of land that she has purchased.
Lord, he has also, Lord, some during pendency by putting wall, he has also acquired
Who?
that Kalpana Rothindranath. Rothindranath is also a member of the club.
No, maybe member of the club.
Yes.
So if the
Club is not registered, my Lord. Kindly, I am not.
suppose that is not a club,
Yes,
some vagabond, they are occupying.
yes.
What to do?
No, I have made party. Rothindranath Saha and others.
Kalpana Saha is not a party.
Kalpana Saha, Lord, is Rothindranath Saha is a member of the club. He has admitted.
Fine.
I need not. Lord, I am telling this for this reason that they are saying that their case is that the entire property 11 decimal belong to Rabindranath Gupta. Kalpana Saha through Sripati Ruidas has acquired 2 decimals. And the municipal authority has had.
You forget about municipality.
No, I'm 3 previous. In the same land. It cannot be said now that whether the Kalpana Saha's 2 decimals there was previous or in my portion. Lord, total 11, I have purchased 9, that Kalpana is 2 through Sripati Ruidas. Therefore, and so far Rothindranath Saha, he is the member of the club, he has admitted. There are other parties. Why should I make the unregistered club a party?
Don't make.
Yes,
Who is forcing you?
Lord, therefore this is, and he has
The
said
suit was not dismissed because club is not a party. Suit was dismissed for some other grounds.
yes, one ground is Lord section 14, another ground is Lord this municipality has not been made party. These are two grounds.
You have implemented Kalpana Shah.
Yes, Kalpana Shah is not implemented.
No,
Kalpana Shah.
I find added wide order dated 14th
Yes.
of December 2001. Kalpana Shah, she has been implemented as
Yes,
defendant number 7.
yes.
But not in the appeal, man. Kalpana Shah died. They have not made Kalpana Shah party in the appeal also.
Memo पे भी जाए। Lord, I have not seen that the Kalpana Shah was added as party. As my Lord points out, Lord,
Eta din to Adito.
Lord, yes, when it fell from my Lord, I am
Oh, just have a look at it. As defendant number 7. This Friday also there is a division bench with 4-5 matters. I am really feeling bad.
added by the 14/12/2001 added by
Let me find out some time. Then
কবে মারা গেছে? Lord, yes, it has added.
she has been implemented as party.
Yes, but Lord, so far
But
Kalpana
in
Shah,
appeal,
her name was not appearing. In appeal, there was no Kalpana Shah.
let them show that they have communicated that Kalpana Shah is dead. It is their duty under Order 2210A. Otherwise, I cannot make her a substitution. At that apart, Lord,
but she has to.
whatever may be the capacity, one of the years at least, Rothindranath Saha is already on record. Therefore, it will not have it. There will be no defect.
Now you are contradicting yourself.
My Lord,
According to you, they did not comply with the provision of Rule 10A, so you are not in the know about the fact that whether Kalpana is alive or dead.
yes.
So assuming she is alive, she ought to have been implemented as a respondent there.
That is correct, Lord. That is correct.
Then
Now she
Lord, whatever it may be,
She died sometimes in the year 2017.
in between,
2017
after the judgment was
after filing of second appeal.
okay.
But she was not included in the first one.
Lord, for the first time, Lord,
Anyway, leave it. Let us forget Kalpana for the time being.
and Lord, this Kalpana Saha was made a party by amendment by court's order. But Lord, I am not aware, Lord, that has been not noted. So for the papers available with me, I have not got it. Whatever it may be. However, Lord, upon death of Kalpana Saha, if Lord was implemented,
When tell me two things. When the amicable partition took place among the legal heirs of the original owner, Rabindranath or Rothindranath, what is the date?
that is, Lord, our deed is,
Your deed is of 1980. There,
Lord, at least it is before 1950.
how to presume that?
Lord, from page 10 of the deed I was reading.
From page 10.
Yes.
Yes.
The entire plot belonged to Rabindranath.
Yes.
His heirs. He acquired in 1950 2 decimals from the heirs of Rabindranath. In
From the heirs
1950.
of Rabindranath.
Yes.
Read again.
Yes. No. Wait a second. Kindly see, Lord, I am reading one. From Lord, page 4, paragraph 2 of the trial court. Paper book. Lord, paper book.
You are referring to the certified copy of the deed?
No, Lord, here admission is there. Lord, kindly see page 4 of the paper book. It is their case, admitted.
What admitted?
No, kindly see page 4.
Yes,
Defendant contended that the shoot plot was absolutely owned and possessed by Rabindranath Gupta.
fine.
And after his demise, the same was inherited by his sons, namely Vishnupada Gupta, Dilip Gupta, Bimal Krishna Gupta, and
Fine.
Kumar Gupta. Transferred, demarcated 2 satoks of the shoot plot in favor of Sripati Duidas in the year 1951.
So they
Therefore-
jointly transferred.
Therefore, my lord, 1951, before 1951, this Rabindranath Gupta died.
Yes,
Lord, we have purchased in the-
1980,
in the 1980.
1980.
Yes.
When the amicable partition among the co-legal heirs of Rabindranath took place.
But might be before 1951,
Why?
because my lord,
They
the
jointly transferred this to Sripati.
1950,
They inherited and
Yeah.
jointly transferred.
1951, 2 decimals.
Jointly transferred.
Yes.
And now you are claiming.
Lord, that's why I'm telling that these persons, they are not at all sons of Sripati, this Rabindranath Gupta.
Fine. You forget about their admission.
Yes.
What is your case?
My case is not that here from the deed itself, it appears that Bimal Krishna Gupta, son of late Rabindranath Gupta, sold the property in the 1980.
In favor of your client.
Yes.
Right. Dilip is one of the sons of Rabindranath.
Hmm.
So there must have been a partition.
Yes.
When the property was partitioned among the legal heirs. If it is before 65, fine. If it is post 65, then by instrument or decree of court. Otherwise, you have acquired undivided share.
But everything will be solved once your lordship reads the plaint. The 2 pages plaint, my lord. That is the pillar, my lord.
Lord, here in the deed, that particular area has been given, but when it was partitioned, that has not been.
That information is not there.
They are not there.
So,
in the deed itself.
So, in worst
Lord-
possible case,
Lord, it,
you could have purchased undivided share of one of the legal heirs. Fine, you have title.
yes.
Admitting that, can you maintain the suit when you are not in possession? That is the question.
Lord,
Section 34 is a bar.
Lord, how, Lord, I have pointed out the case that this is my tile shed room, which they have subsequently they have disposed.
Mr.
This
Ghosh,
is my case.
Mr. Ghosh, read the statement under order 18 made by your DW1
Yes,
together with your cross-examination.
yes.
You don't have exclusive possession.
Lord, I have my residential house.
Fine.
That is that so-called club ghar. Lord, give the photograph. Rabindranath Saha said that there is an altar. There was no existence of the room. Now your lordship will find that during pendency they have constructed room during pendency of the second appeal. After 2015.
But your cross-examination doesn't say so.
The cross-examination he has said.
Room was there.
There is
Room
nothing-
was there. Now it doesn't
was
exist.
there, but not there. is
Now
nothing.
it is not in existence, but the platform is there.
Thereafter, next, is there any document to show it was there? He has said that it was there. But when he was asked, is there any document to show any permission taken
No,
for?
Mr. Ghosh.
Lord, kindly see this. Lord, very important. My valuable property, my own property will be taken away by the club. Lord, kindly see, they have failed to produce a single document that they ever.
What to see? What to see? Now finish. What to see? Just tell me. What document should I look into?
Lord, the club is in existence. They said that club was in existence, but now it is not there. But when he was
Club is
confronted
there.
with the question,
Club
that
is
have you-
there, room is not there.
room is not there, club is
Platform
there,
is
whatever. Is
Yes.
there any document? But their case is they are observing the yearly Durga Puja and other festivals there. Not a single document prior to the filing of the suit. or after filing of the suit during pendency of the second appeal, they have collected some documents that yes, we have taken permission for taking possession, observing pujas.
They
Therefore,
have
my lord,
also filed application for additional evidence.
they
No.
have nothing. They have not done anything. My lord, we
They
have
have, they have procured documents, they have kept it in their custody.
Yes, they
How
have
does
said-
it matter? I'm not going to look
No,
into
no.
their document.
Lord, now, Lord, I am just telling asking before your lordship submitting that my property, they have dispossessed me during pendency of the suit. I have given evidence by way of additional evidence and filed supplementary affidavit in connection with the injunction application with this in connection with this appeal, which is also fixed for hearing with the appeal. Lord, kindly see, Lord, that at least before filing of the suit, club was not in possession. And there is not a single scrap of paper that within the municipal area, a puja is being observed, a club is performing his work, then nothing is coming. Except, Lord, the
But he failed to impeach the credibility of DW1.
Lord, credibility of DW1, he has said that was there. Not at present, there is no existence.
And what about the platform?
Lord?
What about the platform?
Platform was not there, he has said.
Was not there?
No.
Read again.
Lord, he has said that platform was there.
Read again, read again.
Lord, kindly see, I have seen. I have read his submission.
DW1 cross-examination.
Yes. Lord, as a whole, your lordship, kindly read as a whole.
Yes, yes.
Yes.
Then start reading from the affidavit under order 18.
Yes. নালিশি সম্পত্তির পূর্ব মালিক ও দখলদার ছিলেন রবীন্দ্রনাথ গুপ্ত। তার পরলোকান্তে তাহার পুত্র বিষ্ণুপদ গুপ্ত, দিলীপ কুমার গুপ্ত, বিমল কুমার গুপ্ত, দিলীপ কুমার গুপ্ত, নির্মল কুমার গুপ্ত উত্তরাধিকার সূত্রে তার উক্ত তক্ত সম্পত্তিতে সমতাংশে মালিক ও দখলিকার হয়। Lord, kindly for this purpose, I am just showing your lordship. Take, Lord, once this page 15 of the additional this order 41 rule 27. Lord, kindly see the names. This has been written in the written statement also. Kindly see, Lord. This totally fraud. Lord, kindly see this Dilip Kumar Gupta is son of Monindranath Gupta. Kindly come, Lord, page 15.
Yes.
Dilip Gupta, Dipti Kumar Gupta, Monindranath Gupta, Nirmal Kumar Gupta, son of Monindranath Gupta, and Vishnupada Gupta, son of Sis Chandra Gupta. They are not the heirs of Rabindranath Gupta.
How does it help you?
No, I am not.
Our issue is whether you are, Mr. Ghosh, point is very small. Whether you are in exclusive possession of the suit property, you are seeking declaration.
Yes, Lord, at the time of
You read order 18 statement. Just now you have read paragraph 1.
Lord,
you told
Lord,
me that
kindly, Lord, also see my statement.
I will come to that. First,
Yes.
you finish it off.
Yes. উপরোক্ত মালিকগণ সম্পত্তি সমস্ত 1/5 অংশের মালিক স্বরূপে ভোগ দখল করিতে থাকা অবস্থায় 1951 সালে 2 শতক শ্রীপতি দাস নির্দিষ্ট সীমানা চিহ্নিত। Lord, this is contrary to the document, totally false statement, and শ্রীপতি দাস নির্দিষ্ট সীমানার জন্য 10 শতক জায়গা মালিক ও দখলিকার হয়ে তথায় ঘরাদি নির্মাণ করাকালীন তিনি গত 19/10/74 তারিখে তাহা আমার স্ত্রী শ্রীমতী কল্পনা সাহাকে হস্তান্তর করেন এবং তদ্বতী কল্পনা সাহা তাহাতে মালিক ও দখলিকার থাকেন। Then, Lord, this is also false statement.
Fine.
In view of the deed.
Just finish
Just
reading
wait.
the statement.
Falsas in unius, falsas in omnibus. Lord, the নালিশিদার সম্পত্তির 2 বাদে জায়গা উপরোক্ত গুপ্ত ভ্রাতাদের সত্ত্ব দখলি জায়গা থাকে। রবীন্দ্রনাথ গুপ্তের একজন ওয়ারিশ বিমল কুমার গুপ্ত কোসমিনকালে 16 আনা অংশের মালিক দখলিকার ছিলেন না। প্রকৃতপক্ষে নালিশি জায়গা বিমল কুমার গুপ্ত কখনো দখল করেন নাই। Lord, kindly see contradiction.
Come to paragraph.
I'm coming, Lord, one after another. বিমল কুমার গুপ্ত কখনো দখল করেন নাই। নালিশি দাগ সম্পত্তিতে কল্পনা সাহা কর্তৃক দখলীকৃত জায়গা বাদে বকরি জায়গা পতিত অবস্থায় থাকে। কল্পনা সাহা যখন শ্রীপতি দাসের নিকট 34 দাগের সম্পত্তি প্রাপ্ত হন সেই সময় তাহার দখলি জায়গায় দক্ষিণের সমগ্র পতির জায়গা মিনতি পানের জায়গা বলিয়া পরিচিত ছিল এবং উহার পূর্ব দিকে বিশ্বনাথ দাসের পরিবারের লোকজন বসবাস করিত। পরবর্তীকালে উক্ত জায়গা বাদিনী দখল করেন। কাইন্ডলি সি দিস ইজ অ্যাডমিশন। বাদিনী দখল করেন when after purchase.
Finish, don't get excited. You are pretty senior, Mr. Ghosh.
Lord, I'm not
You
excited.
just read.
I'm not excited. Lord, kindly see, note it. It is admission.
Yes, I have read it.
পরবর্তীকালে উক্ত জায়গা বাদিনী দখল করেন। বাদিনী means my lord the plaintiff. Here, কল্পনা সাহার নালিশি দাগের উত্তর পশ্চিম অংশে 2 শতক জায়গা দখলকালীন তাহার ও বিশ্বনাথ দাসের দখলি জায়গার লাগ দক্ষিণে আনুমানিক 3 শতক জায়গা পতিত অবস্থায় থাকে। Then also no club. উক্ত 3 শতক পতি জায়গা নন্দীবাগান বারোয়ারি সমিতির পক্ষে নবরত্ন ক্লাব বাংলা 1374 সালে দখল লয় এবং তথায় বারোয়ারি পূজা অনুষ্ঠানাদি কার্য পরিচালিত হইতে থাকে। উক্ত জায়গায় একটি ক্লাব ঘর নির্মিত হয় এবং ক্লাব ঘরের পশ্চিমে একটি বাঁধানো বেদি নির্মিত হয় ও দক্ষিণে গত 36 বছর পূর্বে একটি কৃষ্ণচূড়া গাছ রোপণ করা হয়, যা বর্তমানে বৃক্ষে পরিণত হইয়াছে। These are in support of this he failed to produce a single.
Anyway, you finish reading.
Yes. উক্ত বেদির উপর প্রতি বছর কালী মূর্তি স্থাপন করিয়া গত 36 বছর পূর্বে কালী পূজার অনুষ্ঠান হইতেছে। উক্ত পূজার যাবতীয় আয়োজন ব্যবস্থা তত্ত্বাবধান করেন নন্দীবাগান বারোয়ারি সমিতির পক্ষে নবরত্ন ক্লাব। উক্ত ঘরে নবরত্ন ক্লাবের সদস্যবৃন্দ নানা রকম ইনডোর গেম খেলিত, খেলার সাজ সরঞ্জাম উক্ত ঘরের রাখা থাকিত। উক্ত ঘরটি পরবর্তীকালে ঝড় বৃষ্টিতে ভাঙিয়া যায়। নবরত্ন ক্লাবের সদস্যবৃন্দ নালিশি দাগের 3 শতক জায়গা 36 বছর পূর্বে দখল লইয়া তাহার উত্তর পশ্চিম দিকে সীমানা বেড়া নির্মাণ করিয়া ঘিরিয়া লয়েন। বিবাদীগণ নন্দীবাগান বাসিন্দা ও বারোয়ারি সমিতির সদস্য থাকায় ক্লাবের অন্যান্য সদস্যবৃন্দ সহিত উক্ত জায়গা ভোগ দখল করেন। This is also important also. পশ্চিম দিকে মিউনিসিপাল রোড হইতে ক্লাব প্রাঙ্গণের প্রবেশের জন্য একটি গেট রাখা। নালিশি দাগে চিহ্নিত ও নির্দিষ্ট 3 শতক জায়গা নন্দীবাগান বারোয়ারি সমিতির পরিচালনায় নবরত্ন ক্লাব বাদিনীর পূর্বাধিকারীগণের আমল হইতে তাহাদের জ্ঞাতসারে 1974 সাল হইতে বিনা বাধায় নির্বিবাদে একাধিক ক্রমে 12 বছরের ঊর্ধ্বকাল যাবৎ দখল করিয়া আসি থাকায় তাহাতে বারোয়ারি সমিতি নবরত্ন তথায় উৎকৃষ্ট স্বাধীন সত্ত্ব অর্জন করিয়াছে এবং সেই সত্ত্ব অটুট আছে। নালিশি সম্পত্তিতে বাদিনী কোনো রকম সত্ত্ব দখল নাই। নোট দি কন্ট্রাডিকশন। বাদিনীর আনিত উপরোক্ত মকদ্দমা ডিসমিসযোগ্য হইতেছে। বাদিনীর কথিত মতো নালিশি সম্পত্তির মালিক রবীন্দ্রনাথ গুপ্তের পরলোকান্তে বিমল গুপ্ত তাহার একমাত্র ওয়ারিশ থাকা বা বিমল গুপ্ত কর্তৃক বাদিনীকে 1980 সালের দলিল মূল্যে নালিশি সম্পত্তি বিক্রয়ের কোনো অধিকার থাকা বা বাদিনী 1980 সালের দলিল মূল্যে সম্পত্তি খরিদ করা বা বাদিনী নালিশি সম্পত্তি বাড়ির সহিত একলপ্ত করিয়া ভূ দখল করিয়া আসা, নালিশি সম্পত্তির উত্তর পূর্ব কোণে 2 শতক সম্পত্তি খোকনবাগ দখল করা বাদে 9 শতক বাদিনীর দখল করা বা সেখানে বাদিনী বসতবাটির ঘর গাছপালা থাকা ইত্যাদি সমূহ সর্বৈব মিথ্যা হইতেছে। বাদিনী আদিতে সম্পত্তি যে বর্ণনা দিয়েছেন তা অস্পষ্ট ও বিভ্রান্তিকর। নালিশি দাগের প্রবেশ পথের দক্ষিণ পূর্বে দিকে বাদিনীর নিজস্ব ভোগদখলীয় টালির ছাউনিযুক্ত একটি ঘর থাকা এবং টালির ছাউনিযুক্ত চালাঘরটি বাদিনী বৈঠকখানা হিসেবে ব্যবহার করা বা চালাঘরটিতে আমরা ক্লাব ঘর করিব বলিয়া তাহা জোরপূর্বক দখল দিব মর্মে হুমকি দেয়া মাননীয় আদালতের দ্বারস্থ হইতে বাধ্য ইত্যাদি সম্পূর্ণ মিথ্যা হইতেছে। মানে দিস ইজ দি রুম I constructed it after my purchase, took possession of the entire land. It is admitted. Thereafter, Lord, this tile set room was constructed by me. I used to use as a drawing room. Lord, when they threatened to take possession, I filed this.
Have you finished reading that?
Lord?
Have you finished reading that? Or anything is left?
Anything left?
Left.
নালিশি সম্পত্তিতে আমাদের কোনো সত্য স্বার্থ দখলিকার না থাকা, নালিশি সম্পত্তি পূর্ব দাগে দক্ষিণ কোণে অবস্থিত চালাঘরে বাদিনীর সত্য দখল থাকা বা আমাদের বিরুদ্ধে বাদিনীর চিরস্থায়ী নিষেধাজ্ঞা সকল ডিগ্রি প্রার্থনার কোনো অধিকার থাকা বা গত 28/5/1993 তারিখে টালির ছাউনিযুক্ত ঘরটি জোরপূর্বক দখল করিয়া লইবার হুমকি দেয়া বা উক্ত তারিখের মোকদ্দমা কারণ উদ্ভব হওয়া বা বাদিনীর স্বামীর পরলোকান্তে উক্ত ঘরটি মেরামতবিহীন অবস্থায় ভাঙ্গিয়া নিশ্চিহ্ন হইয়া যাওয়া বা নবরত্ন ক্লাবের তস্মিনকালে এলাকায় কোনো অস্তিত্ব না থাকা ইত্যাদি বাদিনীর উক্তিসমূহ সম্পূর্ণ মিথ্যা ও মোকদ্দমার উদ্দেশ্যে সৃজিত হইয়াছে। পত্র আদালতে নিযুক্ত অ্যাডভোকেট কমিশনার সৌগত আলী মহাশয় নালিশি সম্পত্তিতে স্থান পরিদর্শন করিয়াছেন এবং তথায় নন্দীগ্রাম বারোয়ারি পরিচালনা নবরত্নের সঙ্গে ঘরাদি থাকা দেখিয়াছেন। বাদিনীর আদিতে বাদিনী উক্তিসমূহের কোনো বাস্তবতা নাই এবং সে কারণে উহার সত্যতা ও সরলতা আমরা অস্বীকার করি। আমরা সত্যতা এবং সরলতা আমরা স্বীকার করি। আমাদের দাখিলি বর্ণনাপত্রের উল্লেখিত বিধানের বিপরীতে বাদিনীর দাখিলি আর্জির কথিত উক্ত সমূহ সম্পূর্ণ অসত্য হইতেছে।
Now come to paragraph 10 and 11. Paragraph 10 and 11 you just read. And show me how it has been dealt with during cross-examination.
উক্ত বেদির উপর প্রতি বছর কালীপুর স্থাপন and উক্ত ঘরে নবরত্ন ক্লাবের সদস্যবৃন্দ নানা রকম ইনডোর গেম খেলিত, খেলার সাজ সরঞ্জাম উক্ত ঘরে রাখা থাকিত, উক্ত ঘরটি পরবর্তীকালে ঝড় বৃষ্টিতে
What is the cross-examination on this?
Yes. Lord, kindly see this. Page 2. I am a member of the Navaratna Club. The said club is not a registered club. The said club had a room and a platform for puja. But at present, the room of the club is not in existence. But therefore, he is saying that in the room.
My question was very simple, Mr. Ghosh.
Yes.
How did you deal with the statement made during evidence in chief
This is the.
that we used to hold Kali Puja every year and we used to do this, that?
Yes, Lord, we have dealt with. I have asked the question.
Show me that.
Is there any document to show? He has said no. No, Lord, can see. The platform is only in existence. There is no permission of the municipality in respect of the room of the club, which was in existence previously.
Fine, it was illegal construction.
Yeah, whatever. There is no document of registration of Barwari Samiti. There is no document to substantiate that there was a Barwari Samiti in the shoot plot locality. There is no document to substantiate that a club puja was held in the shoot plot with the written permission of the local authorities. There is no Kali Puja. Puja was never held. I have
With the permission of local authorities.
Whatever it may be, there is nothing. I had mentioned about the community puja and not about private family puja. I do not have any document to show that Nondibagan Barwari Samiti took possession of the portion of the shoot plot by circumscribing the same by fencing or boundary wall. I do not have any document that is ROR in favor of Nondibagan Barwari Samiti. Nondibagan Barwari Samiti had not paid any revenue, must be revenue to government authorities in respect of the alleged possession of the shoot plot. Not kindly mark here that they are claiming that from last several years, at least at the time of LRROR, they are in possession. But during KB operation,
they didn't do anything.
Yes.
Their possession would wither away.
Lord,
when it is found by even local inspection commissioner, that
Lord,
yes, that is there.
My LRROR says that I am in possession of the entire 9 sotoks. In entire 9 sotoks, no club, no municipality.
That is your reply. LRROR shows your possession.
Yes.
Yes.
And Lord, it is categorically admitted in every respect that there was nothing to show that there was a puja. There is no document.
Yes.
In fact, Lord, the puja is outside on the road. For that, now they are taking permission. And Lord, finally see that he has in his chief stated that after my purchase, I have taken possession of the entire 9 sotoks of land. It is his evidence. That is not spontaneously he said in his affidavit in chief. Affidavit in chief, he has said that বাদিনী পরবর্তীকালে উক্ত জায়গা that is 9 decimals বাদিনী দখল করেন। Lord, page 2, রথীন্দ্রনাথ সাহা statement পরবর্তীকালে উক্ত জায়গা বাদিনী দখল করেন। When they have been dispossessed, বাদিনী has been dispossessed by the club or Barwari Samiti has not been stated. But my case is that at the time of filing of the suit, when they threats that they will threatened that they will take possession of my tile shed room, then Lord, I filed the suit. Apart from the verbal statement, there is nothing on record to show that they were in possession at the time of filing of the suit. Lord, so far, Lord, it has been, the trial court has dismissed the suit on the ground that Kalna municipality has not been added as party, this defect of party. And Lord, another ground that I have no title. I have failed to establish my title on the basis of the deed because I have purchased.
That is not correct, I have told you.
Yes, that
At
is.
best you could have.
Yes, Lord, so far this, during appellate stage, when I filed an application for amendment for recovery of possession, because Lord, this evidence of DW1 says that I was in possession. When they have dispossessed me, that question has not come. I have said that this has been done during pendency of the suit. Therefore, Lord, I filed the application for amendment. Lord, this honorable court and the courts below have every jurisdiction to allow my application for amendment. Thereafter, Lord, found that by evidence that whether
When did you file the application before the learned first appellate court?
Lord, your Lordship, can you see this application? The amendment application to Tarikta. Lord, before decision of the appeal, 2nd or 3rd July 2014.
3rd July 2014.
Yes. Huh? Oh, amendment application. Lord, recovery of first possession, Lord, should to be added.
3rd
By
July.
way of amendment.
3rd July 2014.
Yes.
Do you have copy of the petition with you?
Lord, yes.
Your petition was rejected. Why you were saying it is pending? It was rejected on 12th of May 2015.
12th of May.
I'm sorry, it was not. Sorry, no. On 12th of May, it was taken up for hearing, and ultimately court decided that the matter would be disposed of along with the appeal.
But my lord, in the appeal, it has not been decided.
Hmm?
In the appeal, my lord, there is no whisper about the amendment.
What was your prayer?
Lord, my prayer in the application was
In the cause title of the plaint, in the category of the defendants, after the name of defendant number 6, the following names should be written: Kalna Municipality, Vishnu Pada Gupta, Dilip Gupta, Dipti Gupta, and Nirmal Kumar Gupta. Total 11 defendants.
then, my lord, in paragraph 8 of the plaint, after paragraph prayer D, the following portion should be written in plaint as prayer E, that a degree for recovery of first person of the suit property to be given to the plaintiff as the plaintiff has been dispossessed from the suit property during pendency of this suit. The suit has been dismissed for defect of parties as also, my lord, under the provision of section 14.
Section 14.
Yes.
14 is okay.
Therefore, my lord, especially, my lord, Karna municipality. Karna municipality has nothing. See,
Now the question would be, when did you file the suit?
Lord, suit was filed in 93.
93. They are claiming to have taken possession in the year 1974.
74. They are claiming.
They are
No
claiming.
document.
So there will be another debate whether your amendment should be allowed or being barred by limitation, it should be rejected.
Yeah. No, it is their claim. My case is that I was all along in possession and they have admitted that I have taken possession of the entire 9 decimals after my purchase.
So
that is after 80. That
Have
is
you-
80. Lord, it is admitted position. I purchased in 80 and defendant number DW1 has admitted that I have taken possession of the rest, that is 9 decimals, leaving 2 decimals. Therefore, Lord, it can't be said that they have taken possession in 1974.
very well.
He is one of the members.
Anything else?
No, Lord, I have not finished. I have
No,
placed
just
my
finish it off. Finish it off.
plain case. Lord, now Lordship can see my evidence.
Look, to cut short the matter, one thing could be done. As a matter of fact, this amendment application was not decided by the first step.
But it is not decided because Lordship just now said that it will be taken up along with the appeal. The appeal court says that the suit is itself not maintainable, not complying with Order 1 Rule 8.
Still,
So that's the reason, my lord, it was not taken up.
Still,
Suit itself is not maintainable.
there should have been some remark on the merit of
That
the
is the
application.
only, my lord, fault on the part of the appellate court, that he has not mentioned anything about the pending application.
Yes,
But the suit itself is not maintained.
and they have prayed for recovery of possession, which Mr. Ghosh was saying, no, why should I? Now I find
No.
that in the amendment application, there is a prayer.
Yes.
There is a prayer, and how
Now
far
the question is whether it is barred by limitation. According to you, it is 1974, and according to them, after 80.
1374 PS, Bengali 1374.
No, at one place, in your written statement, perhaps you have written 1974. Just have a look at it. Have a look at it.
check.
Perhaps it is there in.
Yes, নির্মাণ করিয়া বসবাস করে করলেন 19/10/74 সাল তারিখে শ্রীমতী কল্পনা দাস হস্তান্তর করেন আছে দেন Q1.
I have read somewhere.
1974
You are claiming 3 decimal of land which you have been possessing since 1974.
74.
That is your written statement, page 5,
Yes.
paragraph 14. Or paragraph 17, I don't know.
Yes,
Paragraph 17.
paragraph 7, paragraph 14, my lord. You very book said that is no mark.
14 or 17, whatever.
1970.
So even if it is 1974, then the question of limitation will come and there will be some point of argument. It cannot be decided in appeal. You need to lead evidence. He need to lead evidence.
Lordship is.
Now, what else I could do? Just tell me.
Now, boss,
Yes, tell me.
the trial court has decided on 4 points, not 2. Firstly, the commissioner's report, the exhibit C. That is not nullified by them with no evidence at all.
No, exhibit C says you are possessing. The club is in possession. Now he is amending his plaint with the prayer for recovery of possession.
When, my, in spite of due diligence is a factor over there, provides
So,
clause.
According
So where
to
is
Mr.
that due
Ghosh,
diligence?
according to Mr. Ghosh, it was during the pendency of the suit. According to you, well before he purchased. Now, this issue is required to be decided.
True, my lord, true.
Now, how it could be decided?
How
Don't
it is
expect the
relevant
High Court to record evidence.
No scope of High Court, my lord. It has
So-
to be remanded back.
That is what I am saying, without giving further trouble to Mr. Ghosh.
No, my lord, your lordship is doing justice. I am not traveling. Your lordship.
No, I am inviting.
No, no. Your
I am inviting your.
Lord, your-
Actually, I was contemplating dismissal of your appeal.
Lord, I have seen, Lord, your lordship
Only
always not only relying upon the submission of on the part of this part, but not always your lordship notice that looked into
No,
the
it was
records
Mr.
very meticulously.
Boss's client knowledge in 1995, and he is coming up with the amendment application in 2000.
Fine,
That
fine,
is
but
a question of
it
limitation.
should have been disposed of by the first appellate court.
No, that is
Keeping the petition pending, how could he dispose of the appeal?
as because, my lord, it is the finding of the appellate
No,
court.
there
that
should have been some indication.
At least water on rule 8 or CPC, that club.
Now they will take corrective measure.
That is the point, man. They cannot take. They cannot, whatever done, now they are modifying their suit. That cannot be done.
So that is to be considered by learned trial court.
এটা তো করতে হবে না।
Whether he will allow order 1 rule 8 at this stage or not.
That was
The
the,
nature and character of the suit will be.
Absolutely.
That is
Now courts is open before Mr. Ghosh either to come back with a fresh suit.
Yes.
But I won't give him the leave to withdraw, and before the trial court it is to be done.
Why not you?
Now, what is the course left open before us? Just tell me.
the only left open is to remand it back for hearing of the amendment application. So far as I am here, this is my submission because there is no other option open to your lordship right now. That is the only fault committed by the because there was no whisper about the pending
That
application.
is the whole difficulty.
But otherwise, there are so many barriers. Mr. Ghosh's client cannot cross it.
Only difficult is
Advantage of
from
your
whom?
admission.
The total suit is bad. From whom?
From whom?
কার থেকে recovery চাইবে? Club নিয়েছে তো একজনের থেকে পারবে?
Club is not a party.
Not a party, order 1 rule 8 should have been applied by.
That is
my
also a
senior
point.
Client.
That is also a point.
This is.
Lord, I have not filed a suit initially from club. Club story have been that they have that
No, club
invented the
story was
story of club
disclosed, was
without any
disclosed.
document.
No, sir, in the written statement itself.
And that is the reason
নবরত্ন ক্লাবকে পক্ষভুক্ত না করায় মোকদ্দমা ডিসমিস হইবে, that was their constant stand.
But Navaratna
At your peril you overlooked it or ignored it.
my lord, it fell from your lordship that what was the evidence of PW1? Mr. Ghosh was not reading PW1's evidence. Specifically stated that Klapgar was there.
No,
It is there in PW1's
no,
evidence in chief.
no.
Now that is another hurdle, Mr. Ghosh. Remanding the case will not serve your purpose.
Lord,
That's
the-
my-
so
that's the
far, Lord,
point.
that hurdle is concerned. First point, Lord, I will satisfy you with the judgments that it is not a registered club. I am not,
No, then
I cannot, I may not be compelled to make added party.
who will be,
That apart, Lord, some of the members of the club are there.
no, who will be thrown out of the property you own? You are seeking recovery of possession. From whom? That is the pertinent question your friend raised.
That is Lord, the persons in possession, the Rothindranath. He is a member of the.
He was saying two sort of cities possession.
No, no, Rothin-
Since prior to
Rothin-
purchase of.
Lord Rothindranath evidence is they said I am a member of the club.
So,
He is in possession.
Rothindranath alone is possessing the property.
No.
Then,
That's the
Lord,
point
the
I was
club-
raising. How far the
Lord,
amendment is
your
relevant?
lordship knows.
then again,
the
order,
effect may be order
one, rule
order
eight.
rule 2 that leave has not been. Lord, we can during pendency. Anytime your lordship knows, even in notice under section 80, if not given suit is filed, at any stage subsequent to that, court can grant leave. Here also, Lord, if the amendment is allowed, we can allow, we can add the,
Another point I am.
or
placing
we
you.
can take leave. We
Not
can
I
take
just-
leave under order.
So long my friend was saying that those names which are appearing in order 41 rule 27 application, those are not the legal heirs of Rabindranath Gupta. That is a specific allegation in order 41 Gupta.
I mean, that's why, Lord,
In the amendment petition, he says that those should be added.
it was
Those names should be
Lord,
added.
it was given that they were there, that the advice was given from the court that they should be added as party. But it
his
appears,
application point
Lord,
is
I
that
have said, Lord, I have just now noticed from other documents that they are not sons of Rabindranath Gupta.
Mr. Ghosh, we only consider relevant fact and fact in issue, nothing else.
Yes. Lord, your lordship kindly direct the learned court below to consider this aspect of the matter. Lord,
No, the point raised by your friend is very relevant.
Lord, order to rule 8, Lord, that leave I can seek any time during pendency. It is not, it is continuation of the suit, second appeal also. Therefore, Lord, that will not create a bar.
Second appeal cannot be continuation.
First appeal.
That is the first appeal.
No,
is the
when
first
it has been admitted, Lord, lordship is hearing, and this is the, it is apparent that the application
only my role is limited to substantial question of law. If there is any violation, that's it.
Yes. That violation,
Generally, I shall not look into the facts of the case.
That will
Lord,
be reappreciation.
Lord, your lordship kindly see the suit was
No
the
scope.
appeal was admitted on that's solely on that ground. While at the time of admission, this honorable court division bench has not looked into other aspect of the matter. Lord, kindly see. Then, Lord, if it is remanded back for the purpose of hearing amendment application, then, Lord, I shall try to take other steps. এগুলো দিয়ে তো এখানে কাজ হবে না, that we know. Lord, kindly see the ground in which the appeal was admitted. I can confess that that is apparent from the judgment itself that that application has not been touched. Though my lord has rightly pointed out that it was taken up for hearing, and the learned appellate court held that it should be heard along with the appeal. That, Lord, at the time of admission also, the honorable judges.
What's the way out?
Well,
So for amendment application.
But the point is not how far it is material, that amendment application, how far it is relevant. Even if it is sent
Lord,
back.
it might have been rejected by the learned appellate court below. Rejected, it is not merit considering their submission, but it is still pending.
But the question is, I am a very old ailing for more than 20 years. I am bedridden. I have been dragged into this case.
You are Rothindranath.
Yes. I am 78 years old. I am ailing, bedridden.
No,
I cannot walk. Now the question, how is this relevant? when the total suit is not maintainable. How this amendment will help them? Or order one rule it.
That will not decide.
Rule it. Club is not Rothindranath Saab.
No, that we understand.
যেটা দেখাতে চাইছি সেটা করে দিই। দেখি গুগল করছিস
You are representing whom?
মানে 1 2 3 4
But I am asking for response number one.
1, 2, 3, 4.
When there is a large number of parties, you should have taken their name, represented the club, registered or an unregistered case. Now, why I am an old man and the suit is bad. Total nature and character of the suit after WS,
Now
after evidence, after judgment.
appreciating your argument, let me understand. How can I deal with this application under Order 6, Rule 17, which was kept pending by the first appellate court? That is the only point. I appreciate your agony, I appreciate your submission, but what to do with that? Is there any option left other than sending it back
For that application here.
for the application hearing?
Subject to correction, my lord. This suit, they have, in their brain, they said that there is a club who has encroached in my property, rightly or wrongly, but they have said. So the club is there. Now they have come with that they are now saying that the club is unregistered, so need not be a part. Then who will be the part? From whom? He wants to take back that from.
Right,
So,
but can I?
relevancy of that application at the appellate stage, not in the suit, is zero.
But who will say? Who is competent to make such comment? That is the whole trouble.
Yeah.
So far as
Because this is a typical.
how far it is relevant.
So better you come back tomorrow or day after tomorrow.
Tomorrow is very difficult. We have to search it out and find out whether
Typical.
my lord's hands are tied or not.
Yes, you do your research work and come back only on that point.
Next week, at least 2 3 days it will take time.
agreed upon.
But
As an
I
officer
also,
of the court.
no, I shall also try to.
Yes, you do your research work and come back.
Then Lord kindly fix them next week.
Monday,
Only on this point.
only
Monday.
on.
Monday. দেখি এটা করুন তো।
Monday, yes. Monday, Monday.
আর
17 তারিখ।
Mr. Ghosh, learned counsel for the appellant at length. Mr. Chatterjee, learned counsel representing the respondent number 1, and Mr. Mukherjee, learned counsel representing rest of the respondents. Stop. In course of hearing, it appears that an application under Order 6, Rule 17, Order 6, Rule 17 of the Code of Civil Procedure, filed before the learned first appellate court, for all practical purposes, has not been disposed of. Stop. Under such circumstances, the matter is adjourned to appear on 17th of July, 17th,
Monday.
Yes, Lord.
when learned counsel representing the parties would assist the court in taking the right course of action. Only on this point, Mr. Ghosh.
I shall try to assist.
Pending amendment.
Hmm?
No, no, that is
Instead
not-
of arguing
No,
the
no.
exact time,
At
she
the-
could have said that pending
my-
application
my
is
lord,
there.
No, he was also not aware.
No, Lord, I have, at the very outset, I pointed out the ground, the appeal has been added on this ground alone. I read it out. Initially. Before
Now
starting-
tell me whether it should be
Yes.
remanded back or it can
Yes.
be decided here.
এক হাত পেন হয়ে আছে।
What's the age of the litigation?
No, 93.
93,
There was
30
no-
years.
There was no cloud in the horizon from 80 to 93. And from 93 it started.
So,
Scenario change.
no, I'm computing 30 years. We can ensure another 20 years. Don't worry. Yes. Call this. এখন পরেরটা ডাকুন। Next one.
I'm told last 3 occasions, it was the 3rd time. All the time they are not appearing.
They are not appearing. Let me see. What's the issue involved in this application? What is the order impugned?
You know, the order, actually it's a theft of electricity,
Theft of electricity.
lordship. And there were just some orders of the High Court, however, my lord. The order impugned, my lord, your lordship.
So you were representing
The,
State Electricity Board,
yes, now it is distribution.
WBACDCL or
Yes.
something like
Yes,
that.
it is. Where the order impugned also will get there from the prayer portion,
Mhm.
page 31 onwards.
34 onwards. 34, page 34. Page 34 is the last page of the affidavit of some Agarwal, maybe the petitioner, representing the petitioner.
No, 30, prayer person 31 onwards.
31 onwards. No,
Lordship.
I want to see the order impugned. It was order.
Lordship, we do Lordship, a very old brief. However, page 98, 98, well,
98.
8, 97, 98.
Okay. 94, 95, 96. Do you have the copy? Because my bunch stops at page 96.
My goodness.
And followed by a cover letter enclosing the copy of the order dated 26th of May 1996, 2006. If you can lend your copy to me, please.
Yeah.
Do you have the copy of the order? No.
My brief there is
In your brief, it is there.
yes.
Just I want to have a look at it. एक दिन तो ये था.
Sorry. There is a allegation of K. He has refuted, but ultimately the OSD ex officio special secretary last order. If you also kindly see just last 2 lines.
I am of the view that Deputy Chief Electric Inspector violated natural justice by inspecting the place
Yes.
without giving prior notice.
That is the whole crux.
Yes, and also in absence of preparation, I am also the view that burning of meter for lightning even then when fuse system is break. Hence, I set aside the order of Deputy CEI.
If the fuse is there, my lord, then even lightning, just like in our house, if the fuse is there, the question of burning doesn't arise. That is the thing. Probably they have lost their because last two times they didn't appear.
এটা একটু দিয়ে দিন তো. সৌরভ বাবু এটা ফেরত দিয়ে দিন.
And you know, I am putting a question to myself, just my experience. It's a tea company. I don't think that tea company will remain so many days, so many years without any
electricity. Yes.
Why I am saying, my lord, again, for further, that this court directed the rich prisoner to pay the amount, certain amount. I hope he has paid the amount probably. That's why, my lord, he probably is not interested now. Because impossible to run a tea state without the,
correct.
That is why they are not appearing. And this is the 3rd day.
Should I dismiss it for default?
My desire is this, but up to lordship. But I think there's unnecessary. They are troubling this court.
Okay.
I am also troubling this court.
Okay. Take down. As usual. None is appearing on behalf of the petitioner. Stop. This revisional application is awaiting adjudication for last 16 years. A record reveals that the matter was referred to Lok Adalat, where the petitioner did not appear. Stop. The conduct of the petitioner, as rightly suggested by Mr. Pan, by Mr.
Sumit Kumar
Sumit Kumar Panja, learned counsel for the opposite party. কি লিখলাম? Conduct of the petitioner as by Mr. Panja demonstrates the lack of interest to proceed with the matter. Under such circumstances, I am inclined to dismiss the application for default with cost of rupees 10,000 CP. If they appear, they will pay and matter will be restored. Thank you. There are old matters.
I'm sure they are not interested because they have paid the money.
Maybe they didn't appear even in the Lok Adalat also.
Might be.
That is what I found from the record.
Grateful, man.
Thank you.
On behalf of Mr. Sanjay Mukherjee, my lord, I am paying for not today. Here, my lord, now he is engaging code number 759. I am paying for not today. Last
Not
occasion,
today. Very well.
not today. I am capable.
Tomorrow.
Mr. Bhattacharya appearing in this matter here.
Thank you.
Then the opposite party amount has died. I filed an application for substitution of the right. But that application should be allowed thereafter. You have to give direction to sub copy of the application. Notice, otherwise the original has died also.
When did you file your application?
I filed on
কোথায় গেল application টা? It's not with the record.
yes. 22nd February 2015. He died on 1st January 2015. Copy.
Your petition is not with the record.
But CAN number is there, I think, my lord. Because
Can 1 of 15 not in file?
it was filed in code number 14 at that point of time. There's a slip also.
Who died?
Plaintiff opposite of 1, paragraph 3. Leaving behind 1A to 1D. Died interested on first January, leaving behind surviving wife, 2 sons and 2 daughters. And subsequently affirmed on 25th January and filed in court on 26th February. Let's do the time.
নিন আসুন। The plaintiff opposite party number 1, Samiruddin Sheikh, died intestate on 1st January 2015 and right to sue survived upon his widow, 2 sons. As a widow, Begu Bewa, 2 sons, Ajahar Sheikh and Babul Sheikh, 2 daughters, Shalo Khatun and Ujlefa Khatun, who were of sound mind, sujuris. The petition is well within time. And plaintiff opposite party number 1 be substituted by the aforesaid persons as opposite party number 1A to 1D instead and place of opposite party number 1. The petitioner defendants are directed to serve copy of the application upon the substituted opposite parties. Matter is adjourned for 4 weeks with
Yes.
liberty to mention.
Yes.
Mr. Bhattacharya, do one thing, please provide me with a photocopy of the application.
No, that can be kept.
That can be.
Yes.
No, you keep it, you prepare.
I have other copies.
You have other
Extra
copies.
copy.
May I take
Yes,
it?
yes, yes.
এটা একটু লিখে রাখুন তো একটা শুরুতেই লিখে দেবেন can 1 of 2015 is not in file. Stop. Mr. Bhattacharya, learned counsel for the petitioner, provides with copy of the application filed in the department on 26th of February 2015. Stop. Let the same be taken on record.
Only that were the receipt.
Yes.
Final receipt that I said.
Yes, yes.
That can return back.
এটা দিয়ে দিন। এটা রেখে দিন। Can 1 of 15 is thus disposed of. For document.
My lord, item 20. My lord-
20.
My learned friend took the note today. I was at.
Yes.
On this ground, I am paying for not to test because you using.
Are you free now?
Yes.
Look at it.
My lord, I am for the opposite party.
Where is the petitioner? Show
My lord,
of
on the
Shin-
last occasion, Lordship directed me to serve on 27th June order. Lordship directed me to serve. I have served, and this is the
Negative.
affidavit of service. They have received it. Yes, they have received it. The track report shows that they have received it on. Because the learned advocate who was representing them
Hmm.
refused to accept the service on the ground that he is no longer in the brief.
Okay.
So we served upon the party directly. They received it on 8th July. Affidavit of service.
It pertains to an order under section 8.
This pertains to section 8, but my understanding is that this is not under the
The issue is different.
issue is different because I am the preemption has been granted. I am the preemptor. Preemption has been granted by both the courts below on the ground that I am the contiguous landholder.
Hmm. So what to do with this? Should be disposed of on merit?
Lordship may keep it on some other day because in their absence, I am ready. That's not the thing, but because they were contesting before my Lord Justice Vishwajit Basu. They were contesting.
So it can be expected that they will turn up.
They will turn up. They should, because
I
I am
can-
the preemptor, their land will go. I should be fair, my lord. If required, I can give another notice to them. Huh?
See how, let's wait and see how do they react. It will then, let us wait for some more time.
Lordship.
It is better to dispose it off on merit.
Lordship.
Affidavit of service.
It is 2007. And I think there was a direction to bring the lower court records. Lordship.
Yeah, it's there.
It's
It's there with the record.
Yes. Lordship's order was of 5th April 2019.
Hmm. No,
Because
it's-
for all purpose, this partakes the nature of second appeal.
Hmm.
Yes.
No, easiest way is to dispose it off on the ground of default, but That will not serve the purpose. Let us fix it once for all, at least before this court.
Lordship,
Then let them move.
Lordship.
Affidavit of service is taken on record. It appears that notice was served upon the petitioners by the opposite party on 8th of July 2023. Despite service, none is appearing. However, in the interest of justice, I am adjourning the matter quo motu. How many days?
Lordship, I'm not there for the, they have to come, Kothakar party? They are from Birbhum. So 2 weeks would be fair, I think. 2 weeks.
So today is 12. Very well. The matter is adjourned to appear on 27th of July under the heading for orders. If they come, otherwise you will assist me and we will do whatever way it can. Because there is a judgment from Honorable Apex Court that matter should be disposed of on merit preferably.
227, I do not think there is any embargo.
No, I have been disposing it off on merit as well. Yes, Dr. Mondal, what is your matter?
I have 2 cases in lordship list. Today I am not pending them.
2 cases, item number?
Yesterday.
Yesterday, one of your matters was disposed of.
On merit.
I don't know, yes.
Yesterday 2 matters. One is Rubidas, another is Pavok Mitro.
Item number.
Yesterday, item number 11 and 14.
You are having the list of yesterday?
Yesterday.
What's the item number?
Yesterday, item number 11 and 14.
এখন তো কি করেছি হড়পাস করে দিয়েছি দুটোই sorry I have left nothing for you. No, old matters are appearing. I can't keep on adjourning the matters.
I shall see the order and take a step. I shall see the order and
You shall see the order. কোথায় আছে রেকর্ড গুলো সই হয়ে গেছে সার্ভারে উনি আর সার্ভার কোত্থেকে দেখবেন একটু দেখিয়ে দিন ওনাকে
and I am interested in item 14 Pavok Mitro.
What's the issue? LR Act.
No, not ever. The preemption matter.
Preemption matter. Maybe I have adjourned it sine die. In your matter, Bastu, yesterday I passed order in certain matters where Bastu property was subject to preemption and that question is pending before the larger bench. So taking that into consideration, I have adjourned sine die some matters, 2-3 matters. I don't know whether yours is. Better you check it. Thank you.
My lord, kindly excuse me, I could not attend in time number one judgment.
Huh?
I want to see that judgment, kindly permit me. And one thing, my lord, I have been told that Lordship is kind enough to allow the appeal and special measure cost permitted.
That I will dictate.
And another thing, my lord, on furnishing Xerox copy of the judgment and decree of both the trial court and appellate court, I want to take back the original certificate so that
Not Xerox copy. You need to file certified copy.
that was a certificate copy annexed with the memo of appeal.
You want to take it back?
Yes, for execution it is required.
What's the rule? By replacing with photocopy?
Photocopy. Here we usually get
You file application to that.
file on application.
Let it be there. Otherwise, how can I do?
No, my lord, here in High Court on oral prayer.
On oral prayer,
Yes.
everyone act.
My lord, in the subordinate court, time petition application is there. But
That
here,
is different thing. Here you want to take back the
yes,
certified copy.
if your lordship
If
add
they-
an order, add an
If they prefer any civil appeal, civil SLP there,
that copy will be there with the memo. It is a
I will talk to the office.
Yes.
If rule
Yes,
permits,
yes, all right. No problem.
no issue.
All right, my lord. Then I want to see. I do.
এই
If I
জাজমেন্ট গুলো কোথায় আছে গো?
ওই যে 1 নম্বর judgment. একটু দেখুন।
চেম্বারে নিয়ে চলে গেছে? ওকে ডেকে নিয়ে এসে ওনারটা দিয়ে
একটু
দিন।
একটু আনিয়ে দিয়ে। Yes. I am suffering from leg pain. I am a layman, right leg, and left leg varicose problem was there in
No.
year 2012.
Have you
Now it
undergone surgery?
left side just in between knee and ankle.
So you have to undergo surgery.
Yes. Now go surgery, but it is very difficult to stand alone. Now ulcer. Doctor told me venous ulcer. And like পুরা 4-5টা মুখ হয়েছে দেখছি।
No, you should take medicine then.
Yes, I am taking medicine last 2 weeks.
Saurabh, Aditya, call the list. Wait. 22. Then. Then.
My 36, I am appearing on behalf of plaintiff petitioner, my lord.
Then 36, yes. You were Surojit Roy.
Yes, my lord.
Why so many applications are pending in your application?
There is no any application, my lord.
Can 2,
Last.
can 3 disposed of?
Yes, my lord. Lastly, can 1401 probably, my lord, pending, my lord.
Gopal
Mr. Gopal Ghosh, my lord,
Ghosh is
appearing on
appearing
behalf
for
of
the respondent appeal.
opposite party, my lord.
Yes.
My lord,
Was
I am
the
appearing
issue?
on behalf of plaintiff petitioner, my lord.
Plaintiff petitioner.
Petitioner, my lord. In compliance of the direction dated 10th January 2020, passed by Honorable Justice Sampath Sarkar, I am filing the supplementary affidavit, my lord, annexing the orders passed by the Honorable Court and the Commissioner's report.
What is your
This revisional application is arises challenging the impugned order dated 11th April 2014 passed by the Ladnet Additional District Judge Third Court, Paschim Medinapur in rejecting the mis-apping, my lord. Petitioner is the exclusive owner of the tank covered by that number 115 Moja Hiradi, and he is the absolute owner in respect of a tank. And the opposite party admitted that, but they are disturbing by cutting and dragging the mud and develop their property, and a pump house has been set up on the bank of the petitioner's land. Thereafter, petitioner moved a revisional application before this honorable court. In spite of Mr. Gopal Ghosh and their juniors did not appear on first day, Honorable Justice Sanjeev Banerjee passed order, my lord, on 26th August 2014, my lord. Kindly see my supplementary affidavit, page 10 to 60, my lord. (14 to 16, my lord). On 26 August 2014, my lord. My lord, thereafter, they filed the recalling application. My lord, kindly see page 17, my lord. Honorable Justice Sanjeev Banerjee directed, my lord, page 80, my lord. For the moment, the petitioner's right in respect of 2.16 acre of the water body at tag number 115 of Moja Hiradi should not be interfered with or disturbed by the opposite parties in any manner whatsoever. Thereafter, matter appeared before the Honorable Justice Ashok Kumar Dasodhikari. My lord, kindly see page 19, my lord. Page 19, my lord. Considering the facts and circumstances of the case, all the respondent opposite parties are restrained to interfere in the peaceful possession of the petitioner's property, which is a water body measuring of an area of 2.16 acre. If any construction is made over at plot number 115, that construction is to be removed immediately. The concerned video is directed to remove the structure immediately. If any construction is made over at plot number 129, 129 is the contiguous land of the opposite party, my lord. That is to be preserved. Civil Judge Junior Division Second Court, Medinapur is directed to appoint a survey pass commissioner to survey the water body situated at plot number 115 and to find out if any construction was made on any side of the bank of the water body within 2.16 acre. The surveyor is to find out whether any portion of the water body situated under plot number 115 encroach any portion of plot number 116, and the commissioner to demarcate plot number 115 by identified pillars. Survey pass commissioner is also directed to find out what is the area of water body under plot number 115. Report should be submitted. And thereafter, as per direction of the Honorable High Court, Junior Division appointed a survey pass commissioner. In presence of both sides, commissioner submitted a report that the pump house situated on the petitioner's land. Thereafter, pump house was removed by the video, and that order was recorded by the Junior Division. Now the suit is preemptory hearing stage, my lord. Evidence is going on, my lord. My respectful submission before your lordship. Kindly injunction be continued till the disposal of the suit and should be expedited, my lord. My lord, kindly see commissioner's report, my lord. My lord, page 23, my lord. Page 23, issue A. I go to the locality and surveyed the RS plot number 115 on Moja Hiradi, jail number 148 within PS Kharagpur. I have found the construction situated at western bank of the suit plot number 115 shown in red color. My lord, B. I have find out that water body of plot number 115 increased and encroached 0.2 acre portion of the plot 116 is the petitioner is the sharer, co-sharer, petitioner's land, and plot issue number D, direction number D. I have found out that the actual area of plot number 115 as per RS map is 2.16 acre. Water body of plot number 115 and 0.28 acre of plot number 116, jail number 148. The water body of plot number 115 has been increased its eastern side towards the plot number 116 as shown in case map in violet color. There is no chance to any question arise about plot number 129 on opposite parties land. Mouja Kesiasol, jail number 149. Because of that plot is situated another Mouja Kesiasol. The construction of pump house is at present standing on plot number 115, petitioner's land. Mouja Hiradi, jail number 148, not plot or number 129. Mouja Kesiasol, jail number 149. Thereafter, my lord, kindly see page 25, letter of video. Pump house was removed on 3rd August 2016, my lord. And thereafter, my lord, order was recorded before the learned court below on page 27, order number 66, 11th August 2016, my lord. Now the suit is evidence is going on. PW1 gave his evidence, my lord. Opposite party admitted the petitioner's ownership, my lord.
Where?
But they are disturbing, my lord.
Where?
My lord, kindly see page 70, my lord. Order of the Honorable Justice Sanjeev Banerjee, my lord. The opposite parties have applied by the matter. Second, my lord, kindly see. Second,
Your supplementary affidavit.
Supplementary, page 70, my lord. This is the order of the Honorable Justice Sanjeev Banerjee, 19th September 2014, my lord. My lord, the matter pertains to a tank. The petitioner claims to be the exclusive owner of the tank covered by Dak number 115 Mouja Hiradi. The opposite party do not dispute the petitioner's exclusive right to the tank at plot number 115 of Mouja Hiradi, but submit that the opposite parties are the owner of plot number 129 Mouja Kesiasol. According to the opposite parties, under the project undertaken by the state government, points pond is encroached and Dak number 116.
No, what was your prayer before the learned trial court?
Firstly, injunction was refused. Thereafter,
what is the schedule? You prayed for injunction against different number 1 and 2 from cutting earth of the tank
and develop their land, and pump house was foreseen.
And also from making any construction in the bank of the suit tank, disturbing the peaceful possession of the plaintiff. So your claim is restricted to plot number 115.
115, I am the owner, my lord.
Your claim is restricted to this.
Actually, contiguous land is 120. It is the opposite party's land. There is no nexus of 115, my lord.
Very well.
Injunction will continue till the disposal of the suit, and in the meantime, suit will be expedited. This is my respectful submission, my lord.
What is the report of the commissioner? Let me.
My lord, kindly see. I have filed supplementary affidavit, my lord. My lord, kindly see page number. Page number 23. It starts from, my lord. It starts from page 21, and the report is, my lord, page 23, my lord. A result of investigating oblique commission, my lord. A, B, C, D, my lord. And pump house is situated on the bank of my land, my lord, petitioner's land, my lord. So pump house is removed as per order of the Honorable High Court, my lord, by the BDO. My lord, kindly see, my lord, point A, B, C, D.
Yes, Ashwin. No one is appearing, no, on behalf of the opposite party. And the last occasion.
Mr. Gopal was appearing, my lord.
Do you have his number?
I have no number.
This revisional application challenges the order dated 11th April 2014 passed by learned additional district judge, Hard Court, Paschim Mednapur in miscellaneous appeal number 62 of 2011, comma, affirming thereby the order passed by learned trial court in dismissing the prayer for temporary injunction. Stop. Mr. Roy, learned counsel for the petitioner. Text me the exclusive owner of the tank covered by dag number 115 in Mosa Hiradhi, Hiradhi, full stop. The opposite parties do not dispute the petitioner's exclusive right to the tank at plot number 115 of Mouja Hiradi, comma, but submit that the opposite parties are the owners of plot number 129 of Mouja Kesia Sol, KESHIA full stop. এবারে কিছুটা করে দিয়ে ডট ডট দিয়ে দিন, দিয়ে এবার লিখুন, for the moment the petitioner's right in respect of 2.16 acre of the water body at dag number 115 of Mouja Hiradi should not be interfered with or disturbed by the opposite parties in any manner whatsoever. Unquote. Yes, where is Mr. Ghosh, or you will assist the court?
Lordship, I have informed you already. He's on the way.
On his way?
On his way.
Fine.
Just gone 5 minutes past over.
Oh, you ask him to come. It is submitted by Mr. Roy that the suit is.
Thereafter, matter appeared before Honorable Justice Ashok Kumar Das.
No, that's okay. Crux is
Yes.
order of injunction is there. Now, what is the status of the suit?
One suit is going on evidence stage, my lord. Evidence is going
Mr. It is submitted by Mr. Roy that the suit being title suit number.
Title suit number, my lord. I am stating, my lord.
101 of 2010
Yes, my lord.
is posted for peremptory hearing and
Evidence is going on, my lord.
witness action is going on.
Yes, my lord.
Yes.
PWD want further evidence, my lord.
When further evidence is
Yes,
fixed.
yes, my lord. I am stating, my lord. My lord. Next
You are
date-
for the
next-
petitioner.
My next date-
You are for the petitioner. Where is your friend, Mr. Ghosh?
My lord,
Oh,
next
he is
date
there.
fixed 19 September 2023, my lord. 19 September 2023 for further evidence, my lord. Of
Posted
PWD
for-
1.
No, peremptory hearing না। কি লিখেছেন বলুন তো ওখানে? is posted for further hearing on
on 19th September 2023.
19th September 2023.
এটাই তো further evidence of plaintiff, further
Stop.
evidence of plaintiff number.
Check. Therefore, this revisional application may be disposed of with the direction upon the parties to follow the order passed on
Passed on 19th September
19th September 2014
thereafter.
till disposal of the suit. Mr. Ghosh. একটা minute. Order of Justice Banerjee is still in force.
হ্যাঁ, supplement দিয়ে দিয়েছি, court-এর order এ। 19th September, sir.
Yes, yes,
That order is still in force.
ওইটা না স্যার, 19th September.
19th September to
19th September order is just supplementary.
This is supplementary.
এই তো স্যার supplementary। কত সাত করেছি আপনার?
Madam, একটু আসুন। একটা শুরুর লাইন লিখবেন, supplementary affidavit filed by the petitioners, by the petitioner, একজন is taken on record. এইটা দিয়ে শুরু করুন। এবার লিখি।
সাপ্লিমেন্টারি এভিডেভিট একটু কপি দিয়েছি আমরা। এটা না, এটা
কপি নেই।
জাস্ট অর্ডারও তো রয়েছে, এই তো order।
That is the judicial order passed by my Lord Justice Banerjee. It is on record and it was passed in your presence, having heard both the parties.
Yes, that is some lot. But this
19th September 2014.
19th September।
দেখো তো এইটা আছে নাকি?
While disposing of your application,
আগেরটা স্যার, আগের পাতাটা দেখুন,
নিশ্চয় কোনো
আগের পাতাটা। এটা জাস্ট অসংখ্যার অধিকারী order। তার আগেরটা, তার আগের পাতাটা দেখুন। হ্যাঁ, হ্যাঁ, ওই পাতাটা। জাস্টিস সঞ্জীব ব্যানার্জির order।
that order was passed in presence of my
yes, I have seen it, Mr. Ghosh.
kindly
Yes, yes.
Mr. Ghosh is everywhere. The opposite party says that we have noticed.
পাঁচ বছর কুমার দাস।
Recalling it.
তারপরে অশোক দাস অধিকারী order। অশোক দাস, অশোক কুমার দাস অধিকারী। পরে পাতা দিচ্ছে আর।
At his instance, order was recalled.
Yes,
Thereafter,
yes, yes.
like at the time of recalling, Justice Banerjee also reached to pass an order.
Yes, yes, I have seen it.
লিখেছি সব করে। তারপরে পাতা স্যার দেখুন।
Yes, yes, not like that.
তারপরে পাতা জাস্টিস অশোক কুমার দাস অধিকারী order।
Yes. Yes.
You have seen. Yes, yes, What kind of degree? Degree I have affirmed, restored. That degree will be executed. I have restored the judgment and decree. Why you have kept this small appeals pending for such a long period?
এখানে ইনজাংশন চলবে ওখানে শুনে যা হবে হিয়ারিং এ হচ্ছে এভিডেন্স হচ্ছে
Anyway, now it is over. Yes, Mr. Ghosh.
Lord, your lordship,
Let the order be continued.
yes, my lord, your lordship, that may be done, but only thing, Lord, at the final disposal, these observations will not be taken into account.
Yes, very well. You will lead evidence and it will be decided. Ashun, madam. Mr. Ghosh, with all fairness, submits that order passed by Honorable Mr. Justice Sanjeev Banerjee on 19th September 2014 may be continued, but learned trial court may be directed not to get influenced by the observation made by, not to get influenced by the observation made in the aforesaid order. Stop. When the witness action has started, I do not find, having considered the submissions at the bar, comma, anything left to be decided in this revisional application.
What about the
Stop. The
supplemented evidence kept on the
yes. Learned parties are directed to act in terms of the direction, direction given by Mr. Justice Sanjeev Banerjee on 19th September 2014 while disposing of CAN 9432 of 2014 till disposal.
Subsequent order passed by Justice Rudiger.
Matter remains same.
Same. Almost same.
Matter remains same. Your possession should not be disturbed.
Yes.
কি লিখেছেন বলুন? Till disposal of the suit. Stop. Learned trial court shall decide the issue independently based on the evidence on record in accordance with the law. Revisional application is thus disposed of. Copy of the order should be sent down. That will be difficulty. Your counterparts will be there seeking adjournment.
Lord, even now, a direction for early disposal given regarding maintainability of the suit with observation. It was handed over to the learned counsel in the court below. He has kept it in pocket, and days after days, matter is not ordered. This is going on.
Since the revision is going to be allowed.
Order will
Yes.
be set aside.
Allowed only order means
Order will set aside.
order
Order set aside. Order of
ওইটা একটু বলে দিতে হবে। The impugned order passed by learned third court of additional district judge
This is just
in Miss Appeal number
in Miss Appeal number
62 of 2011.
62 of 2011
But
is set aside.
affirming
the decision. Present.
affirming the decision dated 16 July 2011.
It goes.
ওরা বলে ওটা বলে।
এটা দিয়ে দিন তো ওনাকে দিয়ে দিন এটা রেখে দিন রেকর্ডে
Malad, since both the order against us, Malad, that the order passed by the civil judge junior division.
doctrine of merger
Merger.
so
This is my lord's
Deep problem.
because you are from that degree.
Very difficult.
But consider the best part of this difficulty. You will remain healthy.
No,
You can burn your calorie.
Sometimes it may be fatal forward.
I have already crossed 70.
Yes.
So what? 70 is
No,
nothing.
but it creates a lot. We can't run in this way. So many hazards on the way.
No, I was told that all the criminal courts will be shifted to this building
That
and
proposal was there. Yes. It will be convenient for us.
For criminal matters are concerned, they are concerned.
where?
With that central.
No. I used to take up criminal matters in Justice Sinha used to, Samanto used to take up criminal matters sitting in this court. Now, with the change in determination, something has happened.
No, some matters are here, it's nearer. Not the old building.
Adjacent building.
Yes,
Grateful, my lord.
thank you. আসুন, ডাকুন পরে স্যার। Madam,
My lord, 57, my lord. Your lordship, kindly be pleased.
দেখি
No, your lordship, kindly take up next one.
next Monday.
I could not, well, frankly speaking, I could not get myself.
You are representing the
Petitioner.
petition. Madam, একটু আসুন। On the prayer of Mr. Raut, learned counsel for the petitioner, matter is adjourned to appear on
Monday.
17th of July.
Deeply.
ডাকুন 58.
Yes, my lord.
You are
I am for the respondent. my lord.
respondent in 58.
58.
Who is for the petitioner?
Petitioner is my lord.
You don't know. দেখি একটু দিন তো।
My lord, this is not maintainable, my lord. Second appeal is maintainable, my lord.
58 is what? 58 civil revision.
Civil division, my lord.
How come second appeal?
My lord, this is a revisional application has been made from first appeal, my lord. There is no substantial law, my lord.
Let me see.
My lord, this is my vokalatnama, my lord. Old vokalatnama.
Old
vokalatnama, my lord.
Old vokalatnama executed in your favor.
Yes, my lord.
What is the issue?
So, my lord, right of preemption suit, my lord.
Preemption.
Suit. Order passed not my favor, appeal code is in my favor.
You wanted to acquire the property, preemptor or preemptee?
I am a my lord, I am the owner of the property. I am the owner of the property.
You are owner of the property.
Inheritance property. This is my inheritance property.
Then why section 8?
One of the legal heirs has been sold to.
One of the legal heirs transferred his share.
Transferred was sold.
Now you want to preempt that sale.
No, I am not wanted to preempt my.
Then
there is no right to preempt preemption. No preemptive right, my.
Why?
As because this is.
Who are you? Tell me first. Who are you?
I am the owner of the property.
No. In this proceeding, you are opposite party or petitioner?
Opposite party.
Number
124.
124. So you are not the petitioner. Who is the petitioner? Prahlad Boiragi. Prahlad Boiragi and Abdul Aziz Mondal. Prahlad Boiragi filed the missed case under section 8 against you. Did you purchase the property?
No, my lord, I am not purchasing this. This is inheritance property.
You have inherited.
Inherited.
Then why section 8?
Section 8, he's going against section 8 as because Abu Sunnisa has gone in Bangladesh by exchange that is a property to the legal co-sharer, to the legal heirs.
The petitioner of this instant case had purchased the suit property in 87 by a registered deed from co-sharer Habibur Rahman Mondal.
Habibur Rahman, his son.
The
He
other
sold the property.
co-sharers, Archunesa, sold their share to the present opposite parties. So you have purchased from Archunesa and
The petitioner has been purchased. I am for this.
no. You have the copy of the petition.
Yes, ma'am.
Read it. Petitioner is the purchaser and borgadar.
Yes, my lord. Petitioner is a purchaser and borgadar. The petitioner has been purchased the property from Habibur Rahman.
And
The petitioner is asking right of preemption, but
against you.
Against me.
It was challenged and reversed. Why reversed?
And without any cause. Right of preemption suit has been filed.
how this Mauja map was considered by the learned appellate court?
Considered and executed how?
Huh?
I am for the race fund and my lord.
So what, you contested?
I am just, it's not maintainable as because there is no substantial question of law. How it is executed, I am not.
Come to page 7. Come to page 7. এই ল্যান্ড রিফর্মস একটা আছে এখানে, আর তো WBL এর একটা আছে, ছোট বই। চেম্বারে দেখুন, চেম্বারে নেই, দেখে নিন তাহলে, নাহলে একটু আনিয়ে রাখতে হবে। Have you seen that? Ashun. None is appearing on behalf of the petition.
Mr. 1 to 4.
What is your good name?
Muhammad Abdullah Ghazi.
Muhammad Abdullah
Ghazi.
Ghazi. Achha. Muhammad Abdullah Ghazi, learned counsel, is representing the opposite party number
1 to 4.
1 to 4. Not 5, not 5, 6, 7. 1 to 4. Stop. In view of the order dated 21st of June 2023, I am inclined to dispose of the application on merit. Stop. This revisional application impeaches the order and judgment passed by learned Civil Judge Senior Division Bonga, North 24 Parganas, in Misappeal number 1 of 2013, by the impugned judgment, learned First Appellate Court was pleased to set aside the order number 162 dated 13th February 2013, passed by learned Civil Judge Junior Division in a proceeding under Section 8 of the WBLR Act. Learned Trial Court, after considering the evidence on record adduced by the parties and precisely after considering the admission of Abdul Aziz Mondal. Who is that man? Abdul Aziz Mondal.
Owner of the property, one of the legal heirs, but one of the co-sharer.
Why you were saying he is one of the co-sharers?
Legal heir, one of the legal heir.
Where from you are
One of
getting this? Where from you are getting this? What is the evidence? Where from you are getting this?
Evidence, my lord, Abdulaziz now has gone away from the world, my lord.
No, it is the claim of the petitioner that you were a stranger purchaser. It is the observation of both the courts that you were stranger purchaser. Learned Appellate Court set aside the order on the ground that Learned Trial Court ought to have consulted the Mauja map to come to a finding that plot number 468 is contiguous to the plot number 487. On the ground of vicinage, this order was passed. Learned Appellate Court hold that without having the Mauja map, it cannot be said that the plots are contiguous. So the order goes. It's not on the ground that you are a co-sharer and law of preemption is not applicable in you against you. That is not the observation. Where from you are getting?
My lord, first suit has been filed for right of preemption, my lord.
Yes.
Suit has been filed for right of preemption, my lord.
Yes, because you purchased the property.
I am for the risk. I am not purchasing the property. I am legal. I am.
Since you purchased that transaction was challenged in a proceeding under Section 8. Do you have the copy of the application?
Yes, my lord. I have not. Only one divisional application here.
You don't have.
No, I.
Then how could you say? The case of the appellant opposite party, meaning thereby your client. You are representing the opposite parties. The respondent petitioner was never, no, sorry, it's, you were the appellant. You have purchased only 19 decimal of land. You are not claiming the land by way of inheritance. Your claim is that you purchased 19 decimal of land.
Land is an inheritance property.
Where is that?
That's because, my lord, who has transferred the land now in Bangladesh, my lord?
Who has transferred the land? How
After
could he transfer if it is?
After
if-
transferring the land, they have gone in Bangladesh.
If
It's
it
excess
is
property.
wet, if it is inherited by you, how it could be transferred? Inheritance and transfer cannot go together.
No, my lord, at the time of Bangladesh, at the time of riot, my lords, in 1917, they have gone in Bangladesh by exchange the property.
The exchange and inheritance are same.
Exchange the property. Thereafter, my sons and
Take
legal
a
heirs have been
stand,
enjoying
take a
the property.
stand. When you are saying you are inherited it, you cannot acquire it by exchange.
My legal heirs has been enjoying the property by exchange, by inheritance property.
Your legal heirs.
Legal heirs, my forefather has been.
They are not your legal heirs. They are your successors in interest. Predecessor in interest. I'm sorry. I'm also committing the same mistake. Your predecessor in interest. They acquired the property how? In what manner? That was never your case. ধরুন তো কি আছে Abdul Aziz Mondol as OPW1 that Dag number 468 is situated, is adjacent to Dag number 487, which is the suit property, which is the property in question, which is the property in question. Stop. Aziz Mondol, OPW1, admission of Aziz Mondol, na? That Dag number 468 is adjacent to Dag number 487, which is the property in question. Stop. And plot number 468 is owned by the petitioner. Stop. During cross-examination, OPW1 has admitted that Prahlad Boiragi, the petitioner, is one of the adjoining landholders in respect of the suit property. On the ground of vicinage, learned trial court allowed the prayer of the petitioner. Stop. While deciding the appeal, learned appellate court observed that learned trial court ought to have consulted the Mauja map to come to a finding that plot number 468 falls adjacent to plot number 487. Stop. But learned appellate court did not consider the Mauja map as well and refused to take cognizance on the admission of OPW1. Stop. True it is, proviso to section 58 of the Evidence Act confers jurisdiction to ask the party relying upon the admission to prove the same. Stop. But instead of invoking the proviso and thereby directing either of the parties to produce the Mauja map, learned appellate court had no reason to set aside the order passed by learned trial court based on the admission of opposite party Abdul Aziz Mondal, who adduced evidence as OPW1. Who was Sunil Kumar Vishwas? Who was Sunil Kumar Vishwas?
Sunil Kumar Mandal, Sunil Kumar Vishwas is having the possession of 56 decimals by exchange.
Exchange with whom?
Exchange with 468, that number is another one, is another owner.
Who is that another owner?
Another owner, and name I have.
You are building the castle in the air.
Sunil Kumar Vishwas is a new owner. He is now owner and paying rent to government and registered owner. Vishwarad Mandal has bought the property by his brother. Paying rent to government, rent of government.
You do one thing, you come back tomorrow. You study the record, come back tomorrow.
The day after tomorrow, my lord.
Day after tomorrow.
Also, my lord, let the petitioner come.
I don't know if they will come or not. There is no impediment under law. I will dispose of the matter in absence of either of the parties. Based on my poor little knowledge and wisdom, whatever you say. I shall not dismiss any application for default other than without imposing cost. I shall dispose it of on merit. Some respite should be there for High Court as well. এটা করে দিন তো ওইটা ম্যাডাম আপনি সময় পেলে টাইপ করবেন না হলে রেখে দেবেন মিস্টার হোয়াট ও কি নাম ওনার আব্দুল্লাহ গাজী heard the matter in part as suggested by Mr. Gaji. Let the matter appear on 14th of July. এটা ধরুন তো আদিত্য এটা এই তো সব আর এলসি টেলসির পিছনেই তো একটা এলার একটা নিয়ে যাবে ডাকুন এবারে আবার শুরু করুন যেখানে ছেড়েছিলেন আমি ডিসপোজ করি Yes, what is your matter?
My lord, item number 67.
Anything other than adjournment? Adjournment. Go and take your seat over there. Call the list again. Then. Yes, Ashwin. This revision, none is appearing on behalf of the petitioner. In view of the order dated 13th of June 2023, I am inclined to dispose of this revisional application on merit. Para. This application under Article 227 of the Constitution of India impeaches the order number 36 passed by learned Civil Judge Senior Division Second Court Kontai, Purbo Midnapur, entitled Appeal number 72 of 2013. Stop. By the impugned order, learned appellate court was pleased to allow the petition under Order 6, Rule 17 of the Code of Civil Procedure and Procedure Code. না কি বলেছি, Code of Civil Procedure কি বলেছি? And the memo of appeal was amended by incorporating the fact that Srimati Ostrukona Das, defendant number 13, died on 22nd of July 2008. And the decree was passed against the dead person, ignoring the fact that the plaintiff respondent filed an application under Order 22, Rule 4, Sub-Rule 4 of the Code of Civil Procedure, which was allowed. Stop. Sub-Rule 4 of Rule 4 of Order 22 says, inverted comma, the court, whenever it thinks fit, আপনি একটা কাজ করুন, এইটুকু দেখে করে নিতে পারবেন, এইটা থেকে এইটা। Therefore, learned appellate court committed jurisdictional error by passing the impugned order. At the same time, the impugned order appears to be perverse and set aside. The revisional application is thus disposed of, or we can have a copy of the revisional application is thus allowed. Thus allowed, the order impugned is set aside. Copy of the order should be sent down to learned trial court নয়, তো হচ্ছে learned civil judge senior division second court Kontai for information and necessary action. ওইটা দেখেন, পরেরটা দেখুন। Then Yes, take down. Earlier on 7th of June 2023 and the 14th of June 2023, the matter was adjourned suo motu in absence of learned counsel representing the petitioner. Stop. As usual, petitioner is absent. Petitioner is not represented today. Stop. এবারে আপনি ওইটা দেবেন থাপা রবীন থাপা. Stop. In view of the aforesaid direction of Honorable Apex Court, I am inclined to take up the I am inclined to dispose of the application on merit. Stop. This application under Article 227 of the Constitution of India impeaches the order number 83 dated 2nd April 2014 passed by Learned Civil Judge Junior Division First Court Ulberia in title suit number 98 of 2005. Stop. After the cross-examination of PW1 was over, even defense witness after the cross-examination of PW1 was over and DW and the suit was fixed for evidence of defense witnesses, comma, the application for amendment of plaint was filed by the plaintiff petitioner to incorporate certain facts to negate the or to neutralize the probative value of the testimony of PW1 that has come on record. Stop. Learned trial court was absolutely right in holding that the amendment sought to be incorporated is a ploy to fill up the lacunae of the plaintiff petitioner. Stop. The order impugned does not suffer from any perversity. Order impugned neither suffers from perversity nor there is any jurisdictional error. Stop. The impugned order doesn't warrant any interference. The revisional application stands dismissed, however, without cost. Vacated. Then পরেরটা. Both parties are present in any matter? No. Then you wait. Call the list. এটা পাঠানো হয়েছিল? অর্ডার শিটটা পাঠানো হয়েছিল? ডেট রিকভারি ট্রাইব্যুনালে দেখুন received part 1 from the honorable court room number 236. তারপর DIR 28 OC is issued 28 আজকে করাটা ঠিক হবে না, এটা নট টুডে করা থাকে, দুদিন দেখে নি। আচ্ছা একটা অর্ডারই করে দিন এই যে আজ তো লিখুন এই লিখুন petitioner UCO Bank is not represented on 7th of June and 14th of June. Matter was adjourned. Suo motu. Department was directed to send the copy of the order sheet dated 14th of June 2023 under such circumstances, taking into consideration the following observation of Honorable Apex Court given in oita diye deben. I am adjourning the matter till 19th of July. Stop. On the adjourned date, if the petitioner is found unrepresented, matter shall be disposed of on merit. Then Ashun. This revisional application was dismissed for default on September 1, 2014. Thereafter, an application being CAN 9440 of 2014 was filed on 9th September 2014. But none is representing the petitioner. It appears that the petitioner is no more interested in getting the revisional application restored. Stop. Considering as such, this application being CAN 9440 of 14 stands dismissed. Resultantly, the civil revision merits no consideration. Stands dismissed করে দিন আচ্ছা না দাঁড়ান মেরিটেই করে ঠিক আছে চলো দেন পরেরটা মেনটা আগে গেছে মেন তো নেই রাখুন 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 Ashin. This revisional application challenges the order number 21 dated 15th of March 2014 passed by Learned Civil Judge Junior Division 3rd Court Diamond Harbour in P Miss 31 of 12, which is a suit for partition, comma, as it appears from the averment made in the petition. By the impugned order, Learned Trial Court was pleased to adjourn the hearing with cost of rupees 100 and posted the matter on 17th of May 2014 for further hearing of PW1. Stop. An application was filed by the petitioner to determine the valuation of 800 square feet or 840 square feet of land was taken on record, and Learned Trial Court observed that the petition would be disposed of along with the suit. The order impugned does not suffer from any perversity, and there is sufficient reason to presume that the order of adjournment passed on 15th of March 2014 in absence of any order of stay has lost its relevance. The revisional application is devoid of merit and is dismissed. Next one. Take it. For it today. আসুন। This revisional application challenges the order dated 5th of March 2014, passed by learned civil judge, Junior Division 4th Court, Howrah, entitled suit number 94 of 1983. The petition under section 151 of the Code of Civil Procedure, which was filed on 3rd of March 2014 under section 151 of the Civil Procedure Code, was disposed of by the learned trial court and the order reveals that defendant number 19, upon whom the direction was given, did not have the opportunity to make submission opposing the prayer. The impugned order further reveals that on 30th August 1996, parties were directed to maintain status quo till disposal of the suit. Defendant number 19 on 4th of December 2013 purchased the property and took possession and he was trying to fill up a pond comprised within plot number 308. Stop. When the parties are on record, learned trial court could not have passed the order without giving an opportunity of being heard to the defendants, particularly defendant number 19. There was lack of the other principle of natural justice. Since was violated, comma, the impugned order cannot be allowed to remain in force, and the same is set aside. The revisional application is thus disposed of, is thus allowed for them. Then পরেরটা দিন। এদের কার কি ম্যাটার আছে বলুন? What is your matter? Nothing. You have not. Second appeal. And your second appeal. Adjournment.
The side is not appearing preemption matter, Lordship, the matter is pending for the larger bench.
What's the issue? Every preemption matter is not.
Your Lordship, the question is, Lordship, demarcated portion was transferred.
Huh.
And they are claiming, Lordship, that entire share has been transferred of the vendor. But our case is the land was not partitioned among the vendor of the preemptive.
That is the issue pending before the
That
larger.
is the issue.
Okay. Aditya, ওটা কি item number কত 48
48.
দিয়ে দিন তো এই সৌরভ বাবু অর্ডার করা আছে লার্জার বেঞ্চ হ্যাঁ একই অর্ডার করবেন একজন সাইনেড আই লিবার্টি টু মেনশন
The opposite party.
affidavit of
No, only notice.
keep it with you
With track record.
এটা এক্ষুনি করলাম না একটা ম্যাটার আমি করলাম অ্যাডজর্নমেন্ট দিলাম 7 দিন না কতদিন
নাইমুল হক
ইউকো ব্যাংক item number 24
316.
same matter
316.
same order item number 28 19 এটাও 19 19th July adjourned পরেরটা দিন $29 করলাম না এটা এই 28টা হলো 29 দিন সেকেন্ড অ্যাপিল আর কোথায় আছে শেষের দিকে আছে আসুন none is appearing on behalf of the petition. This revisional application under Article 227 of the Constitution of India was filed on 6th June 2014. None appeared on behalf of the petitioner since after filing of this application. The impugned order was passed on 3rd of July 2013. When the prayer of the defendant number 1 under order 1 rule 10 within bracket 2 was allowed and name of defendant number 1 was struck off from the cause title of the suit. as in the suit for partition, defendant number 1 stated that he did not have any right title interest over the property involved in suit. By the latter order, learned trial court was pleased to reject the application under section 10 of the Code of Civil Procedure. Over the period of last 10 years, the matter appears to have lost its relevance, more so when none appeared since after filing of the petition for the petitioner. I am inclined to dismiss this application being bereft of merit. Then Ashwin. Despite service of summon, service of notice, none is appearing on behalf of the petitioner. Distributional application stands dismissed for default with cost of ₹20,000 CP. Then, corrected. A copy of the order sheet coordinate interim order of stay finish stands vacated. Corrected. এবার সেকেন্ড অ্যাপিল গুলো ডাকুন, নাহলে গুলো করে দিচ্ছে না। Doranta. None is appearing on behalf of the petitioner. Hello. Ever Supreme Court judgment, Govind Thapa, stop. This revisional application under Article 227 of the Constitution of India challenges the order number 52 dated 17th of May 2014 by the impugned order.
I
91.
appear for the respondents.
Who is for the appellant?
Appellants will not, next is not for the appellant. Appellants obtained an interim order at the time of admission. It's a concurrent decree of eviction passed by the landed court.
Eviction of tenant or licensee?
Tenant.
Tenant.
Now, my lord, at the time of admission, there was a conditional order of stay of decree. The condition is that he is go on paying
Occupational charges.
fixed at the by the honorable court, 5,000 per month every month. Otherwise, it will stand vacant. Initially, they are paying 5 appellant, 5 respondents, 1,000 per month. Subsequently, stop paying irregular payment. I have taken out a vacating application, which is not can number 9475 of 2017. When it was in the list, Lord.
Yes.
At that time, the Honorable Justice Vivek Choudhury was taking up this jurisdiction. This determination. COVID-19 pandemic broke out. The matter went out of. Subsequently, matter came up for hearing before different.
What's the can number?
Can number 9475 of 2017. Can
9475 of 2017.
vacating application.
Where is that supplementary affidavit?
Supplementary affidavit because initially he was paying irregularly. Some of the respondents subsequently stopped paying totally.
How many responses?
Respondents not 5. 5 respondents.
By the common judgment?
Yes.
No, they,
Yes, it's common judgment. One
no, five different suit properties or
no, same.
same property?
5 owners, 4 owners. In the meantime, what happened a lot? The sole respondent died. The sole appellant died. The appellant died. They have supplied me on an advocate
Hmm.
Thereafter, one of the respondent to be substituted, his wife also died.
So this can 110 disposed of?
Can number, subsequent can 1919 and one application pilot time can 3 of 2018 and can 4 of 2020. Both are substitution application filed by. Thereafter, they are not appearing, either taking service.
No, did you comply with the direction dated 26th of
Yes,
April?
yes.
You served notice?
But kindly, Justice Patnaik, initially.
What is the status of the execution proceeding?
Execution proceedings, I tried to convince that they are not paying, it should stand automatically vacated. Islamic executing court says that.
No, you have filed.
Yes, execution.
Proceeding is pending.
But what happened, Lord?
Hmm.
As per Justice Patnaik's direction, I initially served the learned advocate. He says I have
No.
Later of the
Pallavi Paul.
entire brief has been taken out from, no objection has been taken up. They have taken up no objection. That's why
Suit property is situated at
property situated at
Brahmin Para,
yes.
Khalshani Chandan Nagar.
But they are not taking, enjoying the property without paying anything.
They are not enjoying property.
They are enjoying property without paying.
Bashavi Sen.
Bashavi Sen.
She is a resident of Panchpada, Jirat.
Jirat.
Where is the suit property? Suit property is situated at? Bandel. Manobi Das refused. Are they the daughters? Purovi Vishwas? Huh?
Not it appears from the substitution application. They have filed. They have already filed substitution, but taking no step. Can 3 of 2018. Can 3 and can 4 of 2000.
Who are the appellants? Give me the name of the appellants. Bashavi Sen.
Bashavi Sen, so far as Bashavi Sen is concerned, this is
Bashavi Sen.
He has moved from that residence, that address. But not that is the address I have got from the substitution application. That address I got.
Then Manobi Das refused.
Other says refused.
Purovi Vishwas refused. Pallavi Pal
Learned advocate says
refused. So they are the appellants, substituted appellants.
Substituted, not here.
Where is the application?
Thereafter, I filed another repetitive service. Notice that matter will appear before your lordship. Same fate.
Same fate. What's the substitution application? Can
3 of 2018 and can 4 of 2020 substitution application.
Jharna Pal was the original tenant.
Rajbihari Pal.
Rajbihari.
Pal. Jharna and 4 daughters. Subsequently, Jharna also died.
So basically,
we deliberately avoiding service and last more than 3 years. More than 6 years. Enjoying the property.
Ashun.
Another epidemic.
ওটা নিয়ে নিন তো একটু নিয়ে নিন You are Mr. Chakraborty?
Yes.
When this order of stay was passed?
21st July 2015.
21st July
I
2015.
annex with vacating application. Annexure A, page 13. Annexure A, page 13.
Interim stay will continue till disposal of the application. CAN 6153 of 2015. This is application for stay.
Stay.
Nin. Heard Mr. Angshuman Chakraborty, learned counsel representing the respondent. It is submitted that pursuant to the direction given on 26th of April 2023 by the coordinate bench, the respondent made an attempt to send the copy of the application for vacating the interim order of stay upon the substituted appellants.
Vacating application already served upon the learned advocate. If received earlier the affidavit of service, I sent only notice. Earlier affidavit of service I filed.
No, why there are two sets?
Today I filed two sets. Earlier one another set. Again and again I have to file because it is not.
So
I filed before Justice
ওখানে কি লিখেছে?
10909.
শেষ
This one, copies I have got. Already supplementary affidavit.
No, copy of the application. Sent notice indicating that the petition for vacating the order of interim stay would be taken up on 7th June 2023. All such notices returned unserved. The substituted appellant Manobi Das, Purobi Vishwas and Pallavi Pal refused to receive the notice, and Srimati Bashobi Sen left the address given in the petition for substitution. Stop. The affidavit of service is taken on record. Interim order of stay of the execution proceeding was granted subject to payment of rupees 5,000 per month towards occupational charges. Stop. According to Mr. Chakraborty, learned counsel for the respondents, the appellants have stopped paying occupational charges. Therefore, the order of interim stay cannot be said to have any force, but learned executing court is not inclined to proceed with the execution for want of specific direction. Stop. As the appellants failed to comply with the direction given on 21st of July 2015 while granting interim order of stay, as a natural corollary, there should be no impediment. As a natural corollary, there should be no impediment to proceed with the execution. of the decree. Stop. The interim order stands recalled. Hello. Do you have any application pending?
No.
No.
I have met come out only this application. Other applications are pending, substitution application, they are not taking any step. Only 5. And learned advocate says I have given no objection. And the clients are not taking service. This is
Under such circumstance, let a copy of the order. No, you just take the server copy, move before the learned executing court.
but I may take can be urgent Xerox certified copy learned.
Order the the can number so and so that stands disposed of. 9475 of 2017 stands disposed of. Urgent certified copy is applied therefore. এরপরে এটা করে দিন। Matter is adjourned to appear. On that day, I shall dismiss the appeal on the adjourned day.
But they are not taking stage, no paper book.
Yes,
LCR has
matter
not
is
contained,
adjourned to appear
no stage,
on
only engagement.
27th of July. Yeah, why 27th? After 7 days. Today is 19th of July. Under the heading for orders.
I have some personal others pick up.
20th under the heading for orders. Then. দেখুন। পরপর দেখে দিন।
Item number 94. I'm appearing on behalf of the respondents. There are 2 applications, my lord, Can 2 and Can 3 of 2021. And for the applicant in Can 2, this is called the substitution of the respondent. The applicant in Can 2 is now the successor in interest, because during the pendency of the appeal, my lord, the respondent had surrendered the lease over the suit property, and subsequently the suit property was purchased by a registered deed of conveyance by the applicant in Can.
Let me go through the
Yes,
papers.
One thing may I just submit before your lordship? There are 3 applications which appear to be listed, Can 2, Can 3 and Can 4 of 2020. I have a copy of Can 2 and Can 3. This is actually a changed brief. I do not have a copy of Can 4. The previous advocate possibly did not hand over to my client. Can 4 from the order sheet from the previous order appears also to be a substitution petition on the demise of the sole respondent. But I do not have a copy of that application.
Who is Binoy Kumar Purohit?
That is the learned advocate appearing on behalf of the appellant.
You are representing
I am representing the applicant in Can 2 and Can 3.
Can 2 and Can 3.
Yes, Can 2 Shaheen Khan.
Have you served?
Yes, my lord, it has served, even affidavits have been exchanged. The affidavit in opposition was filed by the appellants. We had filed a reply to that, but I do not even.
Why Can 3?
My lord, Can 3 is for the vacating of the interim order. When the appeal was admitted before the division bench, the 1st of July 2019, the order of the trial court as well as the order of the lower appellate court was stayed.
Is this a suit for eviction?
Yes, ma'am. Eviction of the tenants.
And you have acquired the title by purchase from the owner.
By purchase from the owner, because the petitioner, the plaintiff in the suit was the lessee of the property. Subsequently, he had executed a deed of surrender of lease to the original owner. I purchased the property by a registered deed of conveyance from the original.
Very well. Now, who is this Shaheen Khan?
Shaheen Khan is the applicant. She is the person who has, I am representing her.
You are representing
Yes.
Shaheen Khan. And who is Shakil Ahmed?
Shakil Ahmed was the original respondent in the appeal. He was the leaseholder who was the plaintiff before the learned trial court. He surrendered his lease to the owner of the property. I subsequently purchased.
Who are the owners? Vaidyas?
No, the Vaidyas were the tenants, my lord. They were the defendants in the suit. The owner of the property, my lord, was one Shakiluddin.
Very well. Why so many applications can forward? You do one thing.
Right.
When the matter appeared for the last time,
My lord, the last petition was on 27th of September 2020.
you do one thing. I am fixing a date.
Right.
You notify the appellants
Right.
and come back. Yes. Arshun.
May I seek one indulgence?
Yes.
During that, when I notify the appellants, may I also request us to hand over a copy of the affidavit in opposition? It has already been handed over as it appears from the order sheet.
Why not? Why not?
I
I hope your friend will not mind.
I sincerely hope. I know.
Yes. Heard, Mr. What is your good name?
Dipto Banerjee.
Dipto Banerjee, Learned Counsel, representing the petitioner of Can 2 of 2021, Miss Shaheen Khan, who claims to have acquired title in respect of the suit property by purchase and wants to get impleaded under Order 22 Rule 10, Order 22 Rule 10 of the Code of Civil Procedure. Stop. Since the matter is appearing after almost 1 year, the petitioner is directed to notify the appellants that the matter shall be taken up for hearing on 25th of July.
I'm okay.
You're 141, no?
Yes. 104.
104, 37 matters, yes. Did I dispose of 37 matters yesterday? None. Then tomorrow.
$102.
102. What is your matter?
Section 5 application, my lord.
Section 5 application.
Yes. Almost
Where you fail to set out sufficient cause.
paragraph 3.
Paragraph 3.
Yes.
Not today. Sir, not today.
It has been
Try your luck
served and they have appeared.
Try your hand tomorrow.
All right. Yes, but
Try your hand tomorrow.
Yes, yes.
এই ওনার এটা দেখুন তো কোথায় 104 নম্বরে কি আছে?
Section 5
কোথায় গো এত? হ্যাঁ? হ্যাঁ। 104 লাস্ট ম্যাটার। Mahadev Ghosh. And yours is 102. এটা কালকে এই প্রথম দিকে একটু রেখে দিন, সেকেন্ড অ্যাপ্লাই শুরুতেই রাখুন, আমি করে দেবো।
I'm grateful to the Lordship.
Grateful.
Item 90, 99. Yes, yes. Not today.
No.
Aniruddha Chatterjee will lead you. Very well, you come tomorrow, I will adjourn it. Come tomorrow. You serve on your own and come back. Not today.
With the Lordship.
Be disciplined. What is this?
Yes, yes. We are grateful to the Lordship.
Come back tomorrow.
That's the bottom matter, so it's not reaching.
So tomorrow you come, I will take up your matter. Yes. Gentlemen, what is your matter? 101. You were for the respondent, 101. The difficulty is appellants are shy to appear. So I have to deal with the respondents only. 101.
101.
What's this application, can 1 and 2?
It's a application under section 5, Your Lordship.
Section 5 you are opposing.
I'm opposed.
Very well. Try your hand tomorrow. Let's see.
My lord, item number 92. I'm for the respondent in this matter. My lord, this is a old matter, my lord. My lord, 92.
92.
Yes,
I have dismissed perhaps your matter because I am.
my lord, I'm for the respondent.
You are for the respondent.
What?
92. Minoti Bhadra.
Yes, sir.
Yes. Come tomorrow. Come tomorrow. So many applications are pending. How many are filed by you?
My lord, one application. This is in 2023. That application was filed by me for the expeditious hearing of this application.
Expeditious hearing.
My no requisite, nothing has been filed on behalf of the appellant since filing of this application, filing of this appeal, my lord.
Appeal against?
My lord, the judgment on reversal.
Reversal of what?
My lord, the judgment.
What was the suit?
My lord, suit was for the partition.
Partition.
Yes. The
Preliminary decree
passed by the learned civil judge junior division. Thereafter, the where my application was turned out. Appellant, well, I'm telling you what has happened. The respondent is the plaintiff in the initial suit. It was in 2003, initiated by me. Thereafter, my suit has been dismissed by the learned civil judge junior division. I preferred an appeal, my lord. I preferred an appeal against that order before the learned session judge, district judge. Thereafter, same has been reversed. Against that order, my lord, the respondent, the appellant came up before this honorable court with a prayer.
Come back tomorrow.
As you lordship. Okay, deeply obliged.
Thank you.